Everyone please confirm whether the audio and video both are clear. Everyone please confirm whether the audio and video both are clear. Two to 3 minutes. Let everyone come, join. We'll start. Before that, two basic requirements of every student. Have a pen and a single rule notes, number one. And number two, whatever the question bank or textbook you are following. Even if you don't have that question bank or textbook, I will read the question and I will tell you the answer as well. So no worry about it. Okay. You must keep one pen and paper with you, a book, such that important points as per the section you can start noting it down. Okay. 2 minutes we will start. And very good morning everyone. So let us start our success journey from today for the September examinations. Okay. God bless you with complete success. Put your full efforts. Okay. For 3 days, 3 continuous days the session will be there, 4 hours in each day. Such that we will cover substantial portion of all the important core areas from the exam point of view. Okay. Everyone, please take out the share capital chapter with you. Very, very happy morning, everyone. Please take the share capital chapter. Okay. So the today's targeted chapters are, number 1 is the share capital. Okay. Number 1 for the today's session is the share capital. And number 2 will be the LLP chapter. Number 1, share capital. Number 2, LLP. And the third chapter that we are going to take up is the concept relating to 2 important areas. Okay. Number 1 will be the dividends chapter. Number 1 will be dividends chapter. And number 2, another small area also, let us take 2 big chapters I am going to cover. One is the share capital, another one is LLP. Along with that, why share capital LLP? Share capital 7 marks minimum, LLP 10 marks. 17 marks here we are going to cover. Along with the dividends of 4 to 5 marks, 1000% will come. So 21 marks. Okay. And we will be covering out another very small chapter. Say kinds of companies let us cover. Such that the preliminaries of Companies Act if you cover, we will be covering out somewhere around 25 marks in the today's class. Okay. Keep that consciously in your mind. Let's complete it properly. Everyone, are you ready? Good. So do one thing, everyone. The minimum expectation is share capital and debentures chapter. Please open that first. Let everyone join. 2 minutes we will begin. If you are feeling sleepy now, wash your face and come. But be active in the class. Your session or your success. When you are putting so much of efforts like a yagnam, so efforts are required. prepare properly. September we should never see a different result other than pass. Everyone keep the heading. Share capital and debentures. Open the material you are following for the chapter. Open the material you are following. Shall we begin? Okay, done. So we are beginning. So listen carefully. Okay, from now we are going to revise the concept from the questions. I told you reverse approach we are going to follow. Normal classes, every concept we will read. But now the motive will be, we will do as per the requirements of the examination. Okay, keep in mind about that. Let us begin. See here. First, so once again, very good morning. You should listen carefully, understand entire contents. Any doubts, you can put in the comments box. Once in a while, I will also see that. I will clarify your doubts. Then we will step on to the next category. Okay, let us begin. See, in order to maintain a uniformity, that you and me should have the same level of understanding. I'm taking study material into consideration. Okay, I can take my material into consideration and do that. This is not the time to prove me. This is a time for you to pass, and this is time for me to put efforts on you to pass. This is not the time to show what greatness he is having with Kaushik Mukesh. So please have a right level of books with us, such that I open the study material. I am not going to open any third party material. Question bank only I am opening my question bank, and moreover I am telling you at the beginning itself, the question bank that I am showing you now projecting on the screen, it contains RTP, MTPs, study material book back questions, all those. If you have any other question bank also, please follow that with due respect to every faculty. If you are already following any book, follow that. Okay, since I have mine, I am following that. That's it. I'm not telling that is great. Okay, so anything, everything is great, but I am following what I have. Okay, because I can't take others material and show it to you, so I prepared myself one question bank that I am projecting to you. There is no need that everyone should have that question bank. Okay, I am very clear in certain aspects, so be ethical in that area. So if you are following any other material, please follow that. Proceed. Okay, anyway, answers and questions, RTP, MTP, company level won't change, maybe one or two presentation techniques will change, but answer can't change, so with due respect, let us start with our concept. Okay. So first, share capital chapter, when I say, observe clearly, every single question, whatever is there in the question bank, not required, because I kept 70-80 questions in share capital chapter itself. Okay, reason not to take risk, simple reason, but important things I'm going to cover first. Okay, first we are going to start with question number 2. What is question number 2? Please look into this. Can equity shares with differential voting rights be issued? If yes, state the conditions. This is a 6 marks question, came in exam already, May 2018. Okay, please everyone concentrate first. I will tell you what are all the important points that we need to write in exam. Differential voting right is covered by rule 4. Rule 4 of companies share capital and debenture rules. In this particular rule, differential shares are there. See, I will give you one point first. Concept of equity share capital is covered by section 43. When I'm saying that, simultaneously your hand should move to write the important points. Okay, so differential voting rights, this is a concept we are going to discuss first. In that, what is the first important point? Equity share capital is divided into 2 categories. Number 1, equity share capital with voting rights, equity share capital with differential rights. Class level we can explain hours together to explain what is this differential right, equity share capital, what do you mean by equity, all those things we will do in the regular session. But now understand from the exam point of view what is required. See, equity share capital is divided into 2 parts. Equity share capital with voting rights, equity share capital with differential rights. When I say differential rights, what different? 2 different can happen or not. And see, sometimes normally what happens in a company will declare dividend. Okay, declare dividend on what basis? Per share basis. That's why we call it EPS, DPS. The earnings per share, dividend per share. So always we express in terms of per share. Okay, so declaration of dividend will be happening on per share basis. Okay, next, whenever company general meeting conduct, one share will have one vote. One share will have one vote. Who said this? Section 47 said this. Which section said this? Section 47 said, in case of a vote by poll, every member will have one right for every one share. Means one vote for every one share. Understood the point? So, this is the first point. So, therefore, what is happening? If a person is holding one share in a company, 2 things will come to him. He will get the dividend per share. He will get the voting right per share. But when differential rights are given, rights are different. Means what? They will give higher voting right for lesser dividend, or they will give higher dividend for a lesser voting right. Sir, what do you mean by this? I will give you one share 5 votes, but dividend I will give you 5 shares ki one time dividend. Not per share, I will give per every 5 shares I will give you dividend. For example, if I tell 2 rupees dividend is declared, when I say 2 rupees, now this 2 rupees is not for one share. 5 shares if you hold, 2 rupees I will give. Understood the logic clearly? So beyond this, not required for exam. Don't ask me what is the concept. This is not a time to learn all those things. So now point is, whenever differential voting rights are there, I will give you higher voting, compensate with lesser dividend. I will give you higher dividend, compensate with lesser voting. Any of these two, any of these, not both, any of these two things will happen. Either go for this or either go for this. Then we call them differential rights. What rights here? Differential rights. Okay. Whenever company wanted to issue shares with a differential right, what that company has to do, procedure is involved. One by one, I am telling the procedure. Please listen carefully. First, articles of association must authorize. This is the first point you are expected to write in exam. They will give you half mark. Okay. So articles like it should be there. If articles is silent, okay, company cannot go for differential shares. Alter the articles under section 14 by passing a special resolution, then put the differential rights in your articles, then go for issue of differential shares. This is the good procedure that you need to follow. So first AOA must be there. Next, ordinary resolution must be passed. So SH plus OR plus GM. First one is AOA, second one is SH plus OR plus GM. And next one, are you a listed company? Yes, sir, I am a listed company. Then don't just follow Companies Act, follow rules of SEBI and pass a postal ballot. So general meeting is for normal company, postal ballot is for listed company. Means in examination you should see in the question which kind of company is going into differential issue. If it is an unlisted public company or a private company, general meeting you should conduct. Is it a listed company? Postal ballot, you should do that. Understood the logic clearly? So, sir, nothing is said in the question, sir. Write both the answers. If it is an unlisted company or a private company, general meeting, you have to pass the special resolution. Is it a listed company? Through postal ballot, you have to pass the special resolution. What is this postal ballot? Section 110, we will see in the next day. Management and administration chapter, we are going to discuss about that. Next concept. Next, very, very important. Voting power. I am writing like an equation, please. Voting power for the differential voting shares should not exceed 74% of total voting power. Remember this way. Voting power on DVS, differential voting shares, should not exceed 74% of the total voting power. Students, please clearly listen to this. No jokes. People are remembering and understanding like this. DVR capital should not be more than 74% of the total capital. Wrong. 100% nonsense. No. They said total voting power. How to understand? This is a question. See, there are 1 lakh normal shares in the company. Like this, a question they can frame. Please listen. There are 1 lakh normal shares. When I say normal shares, ordinary equity shares. 1 share, 1 vote, 1 share ki dividend category. Okay, this is the situation. There is a company. That company wanted to give 50,000 DVR shares. 50,000 DVR shares. Okay, with 1:2 voting right. Or sorry, I will do this way. 2:1 voting right. What do you mean by 2:1 voting right? 2:1 means for every 1 share held, 2 votes I will give. How many votes here? 2 votes. Now please tell me 50,000 into 2 makes how much? 1 lakh. How much? 1 lakh. Already how much is there? 1 lakh. So what is the total voting power? 2 lakh. Okay. What is the total voting power? 2 lakh. Voting power of DVS should not exceed, okay, 74% of this 2 lakh. Okay. See. 1,48,000 means the voting power of DVS should not exceed 1,48,000 votes. Okay, 1,48,000 votes. 1,48,000 votes divided by 2. Okay, means you can issue 74,000 DVR shares in our example. Understood? Such that their voting will become 1,48,000. Okay, and now you are giving only how much? 50,000 into 2. They are getting only 1 lakh. Now it is 50%. So you are allowed to have up to 1,48,000 votes. You are giving only 1 lakh votes. So no problem. Like that, you have to understand the total voting power. We are not talking about total paid up share capital. We are talking about the total voting power. Everyone understood the meaning behind the concept behind voting power and share capital or not? Reply everyone. Clear? Yeah. Done. Done. Follow properly. Next. From here, listen. Whenever company is going for DVR issue, I am telling you the logic very fastly and I will go. Okay. Whenever company is going for DVR, what is happening? Normally, one share will have one vote. One share ki dividend has to be paid. Now, company is promising that we can't give you like that. We will pay you higher dividend. We will pay you higher dividend. Compromise on voting. Okay. Or we will give you higher voting. Compromise on dividend. See, two situations. We will pay you higher dividend. Compromise on voting. We will give you higher voting. Compromise on dividend. Okay. DVR shareholders should believe that and they have to subscribe to the shares. What is guaranteed that after me coming inside your company, you will keep your word? You can change the word just like that. Na? Initially, you will tell something, but actually, you will do another thing. What is the guarantee that you will really give me higher voting for lesser dividend or higher dividend for a lesser voting? I will check your character in the past. Listen carefully. I will check your character in the past. I will check 4 characters within you. Character number 1, basic filing have you done? I will check that character. That shows your obligatory or to say compliances. When something is very important, are you complying or not? I will understand through your filing process. Secondly, I will check your financial status. I will check your financial status, whether you are proper in paying the debts or not. I will check your statutory obligatory responses. Basic bonus, gratuity, PF payments have you paid on time or not? I will check. With the banks, did you pay properly or not? I will check. Third one, statutory obligatory compliances. And fourth one, I will check your penal compliances. Means, did you pay any penalty for offenses committed? I will check these 4 things. Remember this way in your mind. I repeat, I will check your filing obligation. I will check your financial obligation. I will check your statutory obligation. I will check your penal compliances. These 4 I will check. If you get clean chit in all these 4, you are allowed to go for DVR, or else you are already defaulted in so many things. Now you are promising that you will give higher dividend. Past you did not pay dividend. Normal dividend. 1 share ki 1 rupee dividend you did not pay. Such a nonsense, worst, nasty track record you have. Now you are coming and promising that they should compensate voting, you will give 5 times dividend. 1 time dividend you don't pay properly in your past track record. How can they believe you? No DVR for you. So like that the sections are framed. Did you understand my point or not, everyone? Everyone, fast. Yeah. So now what is the whole idea behind this? Whenever companies are going for DVR, your character will be analyzed. See, why I am telling the logic now? Exam if DVR comes, even though you forget the concept, Kaushal Mukesh should come in exam. Are you understanding the point or not? DVR means you should get the concept in mind. Yes, DVR means we are checking their character. What character you will check? Say, company has not defaulted in filing finance statements and annual returns for 3 financial years, immediately preceding the financial year in which it is decided to issue the shares. See here. I wanted to ask one question. Every student, please read this part. I will give you 1 minute time. After that, I will ask a question. Okay? MCQ, they can ask question like this. Read that. No problem. I take time. Okay? Read the concept, everyone? Now ready for the challenge? Everyone, are you ready for the challenge now? Okay. Now listen. I will give you a beautiful question. How they can twist your mind in exam like kurkure. Okay? Let us see. We are not going to read just the exam questions. Let us see much more worst case scenario questions that can come. Okay? Let us go for our kurkure question now. See, they will give a question like this. Now the financial year is 25-26. 24-25, 23-24, 22-23. Financial statements, annual returns. Financial statements also called as annual accounts. Here they have given annual accounts. This is financial statement. You can also call it annual accounts. Okay. So in exam, if they give annual accounts, from where this is coming, don't get panic. Financial statements also called as annual accounts. Annual accounts and annual returns. I will ask a question. I filed financial statements for all the 3 years. Okay, I filed annual return for all the years except the second year. Think and answer. Okay, think and answer. I am putting the question before you. This is the question. Okay, this is our kurkure one. Okay, twisted question number 1. Not a tested in exam, but if at all Kaushik Mukesh has to prepare question paper, I would have asked this question. Now tell me, can this company go for DVR? Don't give rush of blood answer, yes, no, all these things. Think first. Take a minute time. When something is asked, take time. Then you give a concept or answer. That's why follow the live properly till the end. So many kurkure questions I have. If you can answer them, any question in exam you will be able to answer. And moreover, I'm not saying that I will exactly stop at 10. If any concept has to be completed, I will prolong to another half an hour. This session is for your benefit. So I will prolong also, no problem. Complete the chapters, that's all. I should not see students failing in the exam again. I hate it. Very good, very good, very good. Everyone answered. See, not defaulted in filing financial statements and annual returns. Here, the most important thing is not defaulted in X and Y. Let us say financial statement is X, annual returns is Y, not defaulted. For example, if you would have written defaulted in financial statements and means both should get defaulted in order to attract DVR non-compliance. Not defaulted in both of them means what? Any one default happens, you cannot go for DVR. And very, very good, yeah, very good, appreciated everyone. So the point is, the word used is and, not and. Two words are there. You should not get defaulted in X and Y. Means if anyone is defaulted in the 3 years, you are gone. Understood the point clearly? And very important next thing. And very important next thing. See, I will ask you a question. We are in 25-26 financial. Okay. 24-25. 23-24. 22-23. 21-22. 20-21. 19-20. Financial statements, annual return. Tell me, now can I go for DVR issue? Now can I go for DVR issue? Can I now move on for a DVR issue? Yes, again, yes. See, they clearly said 3 immediately preceding, not any 3 preceding, 3 immediately preceding financial years. You are in which financial year? 25-26. You should check immediate 3, 24-25, 23-24, 22-23, not all. Next, completed. Next one, very, very important. Focus. Important. Football example, if you miss the points, please. DVR shares, no jokes. No subsisting default means active, existing. Means there should not be a subsisting default. Means what? Past 3-4 years back it was done. Now it is rectified. Those will not come. On the date of making the issue, you should have an active live default. Live. It should be live, not old. Okay? Next. The company has no subsisting default in the payment of what? Declared dividend. You declared dividend. We did not ask you, but you declared, but you didn't pay. Okay. Repayment of mature deposit. Deposits came for maturity. You did not pay. Preference shares came for redemption. You did not pay. Debentures came for redemption. You did not pay. You did not pay interest on such debentures. You did not pay interest on such deposits. So deposits, interest not paid. Debentures also not paid. Dividend payment already covered here. Na? See, I will give you example this way. See here. Subsisting default should not be there in what? Dividend declared. First one, dividend declared. Second one, redemption of deposits, redemption of debentures, interest on deposits, interest on debentures, redemption of preference shares, See, no subsisting default. Repeat again, no active default. For example, today the date is 26th July 2025. Today I wanted to go for DVR. Okay, I should check for the today's status. I means here company. Do my company have any default as on today? Is there any dividend declared but not paid, which is outstanding in the balance sheet liability? No. Deposits are redeemed? Yes. Debentures are redeemed? Yes. Any interest on deposits outstanding? No. Any debentures outstanding interest? No. Do I redeem all my preferences? Yes. You can go for DVR. Understood the point or not? So, if any of these, tell me, everyone repeat, what are the things that are included? Repeat, repeat, repeat. Everyone, read. Hey, you are sitting in your home or you are sitting in a study hall, nothing will happen. It is your study. Repeat. What are the 7 things that we need to remember? 6 things. Dividend declared, redemption, repayment of deposits, redemption of debentures, interest on deposits, interest on debentures, redemption of preference shares. Easy way to remember. If there is a subsisting default in any one of these, you cannot go for DVR. Everyone understood the point clearly? Everyone understood the point clearly? Done. So next one. Next one. F point is much important than all. Okay. Reason I will tell you. See, company has not defaulted in payment of dividend on preference shares. Dividend on preference shares means this is the equity dividend. Dividend on preference shares or repayment of any term loan from any public financial institution, state level financial institution, scheduled bank that has become repayable or interest payable thereon, or dues with respect of statutory payments relating to employees, etc., and IEPF transfer. See, in simple language, if I have to tell, preference dividend, loan from public financial institution, state level financial institution, scheduled banks, state level financial institution and scheduled banks. Next, after that, if there is any interest due on any of these, means either on loan from PFI or SFI or SB, if there is any interest due is there. Next, statutory dues. Next one, IEPF due. These are all statutory dues, means official obligations that you need to do. Those also you did not do. See here, default in payment of preference dividend, where there is an obligation to pay the preference dividend, not like equity where it is optional. It is mandatory. Once the profit comes, you did not pay. Such a nasty person you are, and you are telling that I will give you 5 times dividend for 1 share. How can I believe you? Second, loan. You have taken loan from public financial institution, state financial institutions, banks, and you defaulted to them, and you are not paying. And now you are promising that I will pay 5 times dividend. How can I believe you? Third one, you did not pay interest on any of this. Or statutory deposits. You are such a vulture. You are eating and feeding on the food belonging to your employees and workers in your factory. Such a rogue you are. You are telling you will give 5 times dividend. Who should believe you? In this year cabbage, in this year cauliflower, are you seeing? To believe you. Like this lawmaker also taught. Next, IEPF you have to transfer. It's a statutory obligation to transfer to IEPF. Those also you won't do properly. Do you understand the point or not? Means you are unfit to make a promise, because all your past obligations you did not do properly. Then how can I believe that you will be paying higher dividend, lower voting, higher voting, lower dividend? How can anyone has to believe you? You are cheating your employees, you are cheating your workers, you are cheating the government, you are cheating the department, you are cheating the banks. When there is an obligation, dividend is after all optional, then how can I believe you that you will do? Now did you understand the logic or not, everyone in the class? So that's how this provision was kept. But listen carefully. This is not a subsisting default. This is not a subsisting default. This is a normal default. Means even if you do this default in the past, no active. For example, 10 years back, I repeat again, 10 years back, my loan came for due. 10 years back, my loan came for due. My loan came for due payment. I did not pay. I paid after 3 years. Okay, see, we are in 25-26 financial year. Okay, 25-26 financial year, I wanted to go for DVR. Okay, I wanted to go for DVR on 26th of July. I wanted to go for what? DVR issue. What law said? Law says like this. See, you have loan repayment coming on, say for example, 1st April 2021. Say example, 1st April 2021 ki loan has to be repaid. You did not pay. I paid this on 1st April 2022. 1st April 2022 I paid. Law said directly from 2nd April 2023, you can't go for DVR shamelessly. 5 years again you have to wait. Lawmaker has set this 5 years because in this 5 years we will again check your character. Are you committing any default? Prove that in 5 continuous years you are perfect. Means we believe that you became a normal person, you are no more a cheater. Then after that you can go for a DVR. Do you understand the point, everyone? Important here, DVR. That's why I'm spending time. Again, I will spend time like this in buyback, right shares. Okay, again, small concepts, I will rush to the concept, I will tell. Understood this point or not, everyone? So, I will wait for 5 years. That's why, see, provided that a company may issue equity shares with differential rights upon expiry of 5 years from the end of the financial year in which such a default was made good. Understood the point or not? Read this point clearly. Past default also covered in this case. However, if you rectify the defect, means if you resolve the problem, immediately you can't go for DVR. Again, you have to wait for 5 financial years. Even in the 5 years, if you are defaulting, you cannot go for your DVR again for next 5 years. It will continue till you rectify. See, 5 years has to be counted from default was made good. Means the moment you rectify the defect, from there 5 years. See, date is not 1st April to 5 years. 1st April is the default date. 1st April 2022 is the rectifying the default date. And the default made good. From here, another 5 years you have to wait. Do you understand the point or not, everyone? See here once. I rectified the default on. Listen carefully, like this question can come. I rectified the default on. I repeat, I rectified the default on 23rd August, say 2021. I rectified the defect. Okay, I rectified the defect on 23rd August 2021. Okay, so I rectified defect on 23rd August 2021. Now you tell me, if I rectify my defect on 23rd August 2021, when I can go for DVR? Waiting for your answer. If I rectify my defect on 23rd August 2021, when I can go for DVR? So you will tell that we can go from 24th August, 5 years you need to add, 22, 23, 24, 25, 26. So 2026 August 23rd. Correct? Wrong. That's how you will commit mistakes in exam. See, it's a trap. It's a trap. No, he did not tell the date on date 5 years. From the end of the financial year in which such default was made good, I rectified my defect on 23rd August 2021. What is this financial year? 21-22, when it will end? 31st March 2022. From there you have to count that 5 years. So you can make your offer from 1st April 2027. It's a trap. Over, gone. So that's why revision session I wanted to convey some important points to you. Okay. Concept reading everyone will do. Let's understand where we are committing the mistakes such that we don't repeat. Understood everyone? Hello, I'm talking to you. Understood the logic or not everyone? Okay. So that's very important point you need to understand. Next, lastly, company has not been penalized by a court or tribunal during the last 3 years. 3 years, last 3 means not any 3 last, immediate last 3. For any offense under, they have given 4 acts here: RBA Act, SEBI Act, SCRA Act, FEMA Act, or any other regulator. Okay, sectoral regulator. Sir, what do you mean by sectoral regulator? What they can give an exam? See, there are many government sectors. Those government sectors are having a regulator. For example, insurance is a sector. Insurance is a sector regulated by IRDA. If you are penalized for an offense under IRDA Act, then also you cannot go for DVR issue. That's what he wanted to tell. You paid a penalty for an offense, either by a court or a tribunal, in the last 3 years for any offense committed under RBA Act, SCRA Act, SEBI Act, FEMA Act, any sectoral regulators act. Everyone understood the point clearly? Shall we go into the next one? Everyone? Understood? என்னப்பா புரிஞ்சிச்சா சொல்லுப்பா. தூங்கலையா எவ்ரிவன்? See here now. See here. I will ask a question. Tell me. 2025-26 year. 2025-26 ongoing financial year. Okay, ongoing financial year. Now you answer my question clearly. Answer my question clearly. 2025-26 financial year I am sitting now. Okay. So my question is, in the year 24-25, in the year 24-25, I repeat, in the year 24-25, I paid a penalty of just 1,000 rupees. I repeat, just 1,000 rupees I paid a penalty under, let us say for example, under Insurance Act. Under Insurance Act, I paid a penalty of 1,000 rupees. Will I be eligible to go for a DVR now? Am I eligible to go for DVR? Yes. Hey, one person has given a reverse answer. Shant KJ. You said yes, sir. Enappa? Why yes, sir? Ade. Court or tribunal, anything. Is there anything said in the section about an amount? Everyone? Is there any specific amount given? Until you should pay 50,000, then only attracted for the default. Or if there is 1,000, 1,000 is a very scummy amount. So, who are we to tell whether it is a small amount or big amount? It is about your intention. Understood the point or not? So now tell me, you can go for issue or cannot go for issue if you pay a penalty? Answer is yes, yes, And yes, you can go for DVR even in that case. Yes, you can go for DVR. I repeat again. Yes, you can go for DVR. So doubt will come. Why? Listen carefully. If Kaushal Mukesh has to prepare question paper, na, what I will test? Offense ki you should pay penalty. Penalty will be paid for two reasons. Number one, civil cases, criminal cases. Offense is related to criminal effect. Those only are considered. No, it's not about 3 years or 4 years. Sir. You can go for that unless and until you commit an offense under that act. Offense is different, civil wrong is different. So, how any student will know, sir? Offense is different, civil wrong is different. You must know because it's there in your syllabus. Section number 34, 35, 36 of prospectus chapter. Enna sections? What is there in the section number 34, 35, 36? 34 talking about criminal liability, 35 talking about civil liability, 36 talking about punishment for wrongfully inducing a person to invest money. There you should learn what is the civil wrong and criminal wrong. In the criminal offense, whenever you committed offense under any of these 4 or 5 acts in any of the last 3 years, and then you are penalized, those only will affect your DVR issue. Civil liabilities don't attract. Understood or not, everyone? Live when you are sitting, have a habit of sitting consistently. Okay. If you sit consistently, you can understand. You will come, you will go, you will come, you will go means what you will understand. Sit consistently. I'm seeing some people going in and coming out, going in and coming out. Do you think it's a party hall? So that's the point you need to understand. Okay. Now my final question on this particular DVR. Okay. We spend a lot of time, around 40 minutes I spend because it's required for DVR. Like this, it's not required for other sections. Again, buyback we will spend time. Okay. Now, everyone, think and answer. Now we are in 25-26 financial year. Okay. Listen carefully. 24-25. How many years I have to go back? How many years I have to go back? Everyone, how many years I have to go back? Repeat, how many years I have to go back? 3. 3 ವರ್ಷத்துல I should go back or not? So, see, sorry. Okay, in this 3 years, sir, for 25-26 year when you are going for DVR, I need to go back and check 3 years. First of all, tell me, correct? I need to go back 3 years, correct or not? Wrong. Wrong. They did not say 3 financial years. They did not say 3 financial years immediately preceding the financial year. From 2020-25, the date on which you are going for DVR, from there 3 years you have to take. Date on date years. It's not financial years. Not calendar year, not financial year. It's a date to date years. Means what? You are going for a DVR issue? Yes, sir. When you are going 26 July, last 3 years, 26 July, 26 July, 26 July, 26 July, 26 July, 26 July. Like that you have to take. Or else nonsense, yeah. I committed the offense under FEMA just 1 week back, paid 1 lakh rupee penalty. You will look into the 3 years before and say, hey, I did not pay any penalty 3 years before. He has done FEMA default just 10 days back. You are allowing him for DVR. Provisions of law can never be taken for the advantage of any person. They understood or not, everyone? Heart pain, yeah, answer properly. Understood the point or not? They never said it should be. Okay, from financial year. Okay, so see, the intention of this session itself is we are not just going to read the concepts. Yeah, see, if I have to read the section, how many minutes it will take? 5-6 minutes, like, and complete for formality. I am here to clarify your doubts. There should be and should not be a doubt after this revision class. You should get all things in your control. So that's the confidence that you need to get after the session. So please. Sorry. Anyway, you understood this point now? That's why they did not use the word financial year. They used the word last 3 years. Okay, last 3 years, not last 3 financial years. See, provisions of law, if there are something inside the provisions put in the Bare Act, never it should be taken for our advantage. Never it should be taken for our advantage. And whenever the law came into existence, it should not work. Something is wrong, you should not do, I said. Those sections you should not take for your advantage. Understood the point or not? So, sorry. Anyway, early morning, we are having session. So many students joined live. You are so many interested students are there. Who said students are not serious? See there, 260, 270 students are standing live. So that's the seriousness of CA interest students. Sorry. Early in the morning, for understanding the meaning of what is lawmaker wanted to tell in this last 3, I will tell you a small cutie story, such that in life you will never forget how to read the law. Adi DT, income tax, GST, Companies Act. Listen to a small story. At least it will refresh your mind. Okay, small story. Just 2 minutes will complete it. But listen carefully. You will understand why I said this story. See, long ago, so long ago, Kali Yugan, before Dwapara Yugan, Treta Yugan time. Okay, even not Treta Yugam, Satya Yugam, Treta Yugam, Satya Yugam ending. Satya Yugam, first Yugam ending time. Okay, ending time. There is one king who used to there is a Rajam called as a Kausal Rajam, which we call Ayodhya now. There is a king called as Dasaratha, father of Rama. Okay, at the end of first Yugam, he was there. He was a king ruling the kingdom called as Ayodhya, now what we call. Sorry, what happened is that person is a king. King always have a habit of going to the forest, jungle, hunt the animal. At that time, long years back, because always we believe at that time 40 years, 40 lakh, 50 lakh years back, humans are always meant to hunt the animals. Kings especially, he used to go to the jungle with his team of around 4 to 5 ministers, and he used to hunt the animals. See what happened. One day he was going into the forest. Okay, he was going into the deep, dense jungle. He is going inside. Suddenly, in a particular bush of plants, whatever is there, some moment came. He thought that there is a deer or something is there. Let us hunt it. Immediately, he pulled his bow to the back, complete strength, and he released it. That arrow went in a minute of a second and hit that, and immediately that died. Immediately he wanted to see what it is, and he went. A small kid of 16 years age is dead. Okay, he was about to die in the last moments of his breath. Immediately he asked him, "Are Yarrani, who are you?" "I'm very, very sorry." He started crying like anything, the king Dasaratha. And he asked that person, "Who are you?" That person said, "Sir, my name is Shravana. Okay, my both of the parents are blind. They couldn't see anything. I am the only son who should be there to take care of them. So, but you killed me. I don't know what to do. Actually, I came here to collect some water in these leaves. They are in thirsty. They are about to die if I don't feed them with water. That's why I came here. You killed me. What wrong I have done to you?" He cried like anything. Dasarada, he took his dead body on his hands. Okay, and he found that he is dead already. He kept aside, and he took that leaf and took the water, took to the parents. Okay, do you know how Shravana used to carry his parents? on a balance. A stick will be there, left side father, right side mother. He used to put both of them in a balance and he used to walk. Okay, what he has done, he has given water to both of them. They are asking him, where you went, so long time you have taken, but he is not replying, just feeding the water. Okay, they had some amount of water, and again Dasharatha took them into his shoulders and he carried. Dasharatha height will be long person, na? So this fellow is 16 years age, a short fellow. When the length is increased, immediately they understood why we are raised to such a great level. No, you are not Shravana. Who are you? They said. So immediately wept and screamed and he said, this is what happened in the flashback. Everything he explained. Parents got furious on him. You may be a king in a kingdom, I don't know. But this is wrong. Then they said, we came to jungle. You kill my son. You will also face the same thing. You will also face the same thing. Your son also will come to the jungle and you will die. Not your son, you will die in exile. He will go to forest, he will go to jungle. Then you will also die like us. Both the parents died in that pain. Okay? Dasharatha immediately asked both the parents, please curse me one more time. Are you mad or what? Are you muttala? I am saying that your son also will go like this and you will die. He said, please curse me one more time. Hey, check. You will also face like us. They died. Dasharatha was extremely happy. Now you will get a doubt. Sir, they are cursing him that he will die after his son going to jungle. Why he is so happy? Reason is the provisions of law punishing him are made to his advantage. Do you know why? Dasharatha was actually crying for a son. Dasharatha don't have sons at that time when that curse was imposed on him. He don't have sons at all. Actually, he is praying gods to get a son to run the kingdom as a legacy. Because of this curse, son has to be born. Na? Penalty now added like an advantage to him. Like that lawmaker should not do. That's what I wanted to tell you. Understood the point now? Never a penalty should turn into an advantage to a person. Na? Even that mythology can make a mistake. Lawmakers never do. I think you understood the concept clearly. Yeah, it's always about Companies Act is about the best narrative. How best you can give in Companies Act, that much best you can understand company law. Yeah. Never a penalty should turn as an advantage to anyone. Their curse advantage, na. Actually, I don't have a son. In order to activate your curse, I should first get a son. I will die definitely. I already lived for so many years. Na. I'm ready to die. But I don't have a son because of your curse. Now I got a son. I'm extremely happy. Thank you very much, Shravana, he said. Now, do you understand the entire logic what I said? So, from this, what is the whole story that you need to understand? Last three means lawmaker did not write immediate last. Last three. Okay? Immediate 3 means 3 years you will take, calendar years or financial years. He said last 3 years means what? Year to date year you have to take. Which one? Date to date. Or else common sense are not there. Na? You paid penalty 10 days before DVR issue and you are telling no problem, go for DVR. You paid penalty 2 years before. You are telling nakko, no, don't do, venna, like that you should tell. Her. So, logic. It's all about logic. So, next. So, I think we have done enough research on DVR. Never forget the question again. Okay, next one. See here. Babu, very, very important here. Listen carefully. Ikkada chudu. Inga par. Idhar dekho. See here. Forged transfer. What is the concept here? Forged transfer. Let us understand what is the concept of this forged transfer. Let's read the question first. We, the transferee, acquired 300 equity shares of ABC Limited from S, the transferor. Listen to the question. S is the transferor, V is the transferee. Okay. S transferred shares to V. 300 equity shares of ABC Limited. But signature of S on the transfer deed was forged. Okay. Forged transfer deed. We, after getting the shares registered by the company in his name, we, after getting the shares registered in his name and subsequently sold 250 shares to X. Only 50 shares he has. 250 is sold to X on the basis of share certificate issued by ABC Limited. V and X were not aware of forgery. V, X don't know about forgery. Explain the rights of S, V, X again is the company with reference to the aforesaid equity shares. Bro, everyone please note down properly. Expected question. It can blast your face in examination hall. So please read the question properly. Read the question properly, please. Okay, read the question properly first. Okay. Everyone, read the question or not? Everyone, have you read the question? Listen now. Listen. Everyone in the class, you please come to study material. Come to the area called as a forged transfer in the study material. Forged transfer in your study mat. Sir, if you have any page number, please let us know. Yes. See here. Page number 4.4. Page number 4.4. Page number 4.4. Okay. Page number 4.4. Most important for September 25. If not given in September 25, Jan 26, fix this question will come. Are you all listening, everyone? Please don't drop your concentration at any cost. Can we continue? Okay, see here. A forged transfer is a nullity and it is not legally binding. Forged transfer takes place when a company effects transfer on shares on the basis of the instrument of transfer containing forged signatures of the transferor. Is it possible for the transferee of the forged transfer to acquire ownership on the shares? Answer is no. At the same time, the transferor, who is the real owner, continues to be the shareholder, and accordingly the company can be forced by him to delete the name of the transferee and to restore his name as the owner of shares in the register of members. Read it properly first. Read it properly. Concentrate, concentrate, everyone. Read it properly. Okay. Read the question. Okay. See here now. So what is the whole idea behind this? I gave time for you to read because you should remember the content properly. See, whenever there is a forgery, whose signature will be forged? Seller's signature will be forged. Who is a seller? Transferor. If his signature is forged in the share transfer deed, then that transfer is not valid. It will become void. Why? What is the reason? Simple reason. No consent, no contract. Contract will not happen. Transfer itself will become ineffective. Ineffective. There is a person XY. Okay. There is a person called as Mr. A. A forged the signatures of X and transfer the shares to Y. And transfer the shares to Y. And the X transfer deedler, X signature was forged by A, and A said, I am an agent of X. He sold the shares to Y. Y is an innocent fellow. He paid money to X and he got the shares issued in his name. Company also registered. Later, X filed a complaint to the company saying that, "Are company, how come you will register? I did not do anything." He filed a case in the court and he won the case. He proved that he did not transfer. It's a forged document. Now what company has to do? First cancel that transfer, take back shares from X, Y and give back to X. Y name is already entered in the register of members. Na? Delete it, rectify and make again X name to come into the register. This is one point. That's what you wanted to disclose here. Restore his name. His name is whose name? X's name as the owner of shares in the register. Now the question. What will happen if the transferee of the forged transfer the shares to another buyer? That's what they asked in the question in the exam. For example, X gave to Y. Y's name will be removed. Even before X realizing all these things, if Y transferred it to Z, then what will happen? See, what will happen if the transfer of the forged transfer the shares to another buyer who does not know about the forgery, and the company also registered the transfer in the name of new buyer and endorse the share certificate, then what will happen? In fact, company cannot deny the ownership rights of the new genuine buyer. He is a genuine person. Na? He don't know any mistake. But it can also not deny the ownership of the original shareholder. Now, it is a sword which is sharpened on both the sides. X innocent fellow, Y innocent fellow, Z innocent fellow. Then who is the Bakra now? Ready for Kubani? Why? Yeah? That's why what they said, see here, lawmaker will never commit mistakes. Na? See what happened. See, they are saying like this: X, Y, Z. A is the main villain. Okay. He took shares of X, forged, transferred to Y. Y paid consideration to A, who is acting like a agent of X. Forgery happened. Y took the shares. Done. Y transferred the shares to Z. Y transferred the shares to Z. Okay. Transferred. Okay. Y transferred the shares to Z. Correct. Now, what is the position of Z? What is the position of X is the main point here. X is a real owner. He did not give any consent. So, there is no contract. So, X name will be restored in the register. But even before all this happens, Y transferred shares to Z. Z is a much more innocent fellow. He don't know anything. Understood? He don't know anything about what is happening. In the case, see here what they said. In fact, company cannot deny the ownership rights of a new genuine buyer, Z. But it can also not deny ownership rights of original shareholder because forged transfer is void ab initio. And therefore, company has to restore his name. So, X name will come back into the register. Adi pakka. While restoring the name of original shareholder, company may be asked to compensate the new buyer who exercised in good faith. Company may be asked to compensate, okay, the new buyer, that Mr. Z, who exercised good faith in purchasing shares. As a remedy, company may itself indemnified by first transferee who used the forged transfer of shares to get the shares transferred in his name. Read this paragraph. Exam lo you have to write as it is. Please take care. I will give you a summary notes on this. Copy down. But before that, please read this document clearly. Please read here, please. Important, I am requesting you. This question will come in exam. Read it properly. Okay, everyone. Can we now go to the notes? Everyone, can we go to the notes? Original shareholder means X. Can we go to the notes? Now, open your notes wherever you are writing. Write down. Keep the heading forged transfer. Forged transfer. Forged transfer. Okay. See, in exam question or in any other question, how institute is assuming is important. Some students are already asking the doubts in the YouTube comments box. Others see the doubts, how valid they are asking the question. Who said that CS student don't listen? Yeah, it's all about the ecosystem we sit in. They will be serious. See how they are asking questions. See, just I'm very happy for them for asking those kind of questions. See the comments box. Balakannappan has asked one question. Charan Kumar Reddy asked a question. Next, Kamalesh Kumar is asking a question. See what they are asking. How valid the doubt is. Do you know what is the doubt? Sir, what happens to Y? What happens to Y? In our example, XYZ, what happens to Y? See, here, institute is assuming, okay? In exams also, you should also assume that way. Institute is assuming that Y has done the forgery. Means Y does the forgery of X and transfer the shares in his favor. That's how the assumption was taken. In the exam, if they tell some other person forged and send the transfer of shares, means okay, then different issue will come. But in all exam questions, institute's assumption is the villain is Y. Means what? X, Y is Z is there, na? Okay. X signature was forged by Y and Y is transferring the shares in his favor only. Understood, everyone? Okay, see here now. So write the notes, write the notes properly. XYZ. Real owner. Transferee. Forged signature of transfer. This is assumption. Innocent buyer. Innocent buyer. 3 persons are there. Okay, one by one, let us understand the scenario of all the 3. Okay. Rights of X. Write down first. Rights of X. Write down properly. I will answer all your doubts first. Write down. Okay. Write down. Rights of X. Number 1. Point number 1. A forged transfer is null and void ab initio. I am giving simplified answer. 4 marks it will come. 4 marks you need not write entire Mahabharatam. So you need to write what is required for examiner. Write down. Forged transfer is null and void ab initio. Don't go out of live here. Be consistent. Be consistent. So forged transfer is a null and void ab initio. And therefore, transfer shall not take effect. And therefore, transfer shall not take effect. And therefore, transfer shall not take effect. Transfer shall not take effect. Full stop. Point number 2. In the same. Rights of excellence in the same. Even if company effects the transfer, effect, not affected, not AFFECT, effect, EFFECT, and bringing into existence. Even if company effects the transfer in the name of Y, even if the company effects transfer in the name of Y, X can still claim, X can still claim to re-enter his name into the register of members. Re-enter his name into the register of members. Re-enter his name into register of members. Full stop. Third point. Where there exists a forgery, where there exists a forgery, it is not a voidable contract. It is not a voidable contract. Where there is a forgery, it is not a voidable contract. Rather, it is void. Rather, it is void. As per the rule, no consent, no contract. As per the rule, no consent, no contract. As per the rule, no consent, no contract. Number 2, rights of X completed, rights of Y. Rights of Y. In the brackets, you write down, assuming that Y has done the forgery. Assuming that Y has done the forgery. Assuming that Y has done the forgery. So if Y has done the forgery, what will happen is a question. Okay, continue. A. Y's name, even though entered into the register of members, Y's name, even though entered into the register of members, Y's name, even though entered into the register of members, Y's name, even though entered into register of members, will be, Y's name, even though entered into the register of members, will be deleted by the company, will be deleted by the company, and X name will be restored. X name will be restored. X name will be restored. Next, rights of Z. Rights of Z. Z is an innocent buyer. Z is an innocent buyer. Z is a innocent buyer who bought the shares in good faith. Who bought the shares in good faith. Who bought the shares in good faith. That means without having a knowledge about the defect. Without having the knowledge about the defect. Without having the knowledge about the defect. Okay, but still he cannot claim the ownership. He cannot claim the ownership. He cannot claim the ownership because a buyer cannot acquire better rights than that of seller. Hey, you remember na Sogala, there is one concept, Nemodot quod non habet. Okay, a buyer cannot get a better rights than a seller. Na? Seller have no rights, means how buyer will get a better rights than him? He will not. So a buyer will not get a better rights than that of seller. Better rights than that of seller. Next point. However, However, being a bona fide buyer, very important point here, write down. However, being a bona fide buyer, Z will be compensated. Z will be compensated by the company. Z will be compensated by the company. Z will be compensated by the company. Next point. Company will be indemnified by, means whatever they paid to Z, who should indemnify? The forger will indemnify. Company will be indemnified by Y, who has forged the share transfer deed. Who has transferred the share transfer deed. Okay, this is the answer here. Okay, you need not follow anything. Simply remember this and write down in the examination if a question comes. Now, last doubt. Sir, if Y is innocent, what will happen? If Y is innocent, A is there, on A, Y has to file a civil complaint in the normal court of law and then he has to get back his money, not under Companies Act. Okay, Y has to file a case against A and get the money, but they are not asking questions that way in exam. So your assumption should start in such a way that the transferee is the villain there. Everybody in the live, did you understand the entire concept clearly? Hello, I'm talking to you. Yes, that's it. This is the end of the story relating to the concept of forged transfer. Better than this, I have given a simplified answer for you. Okay. Next, important questions only I am covering. Okay. Babu, Chitti, Bujji, Kanna, see here. Another expected question for your exam. Section 48. Section 48. See, 48 section is important. Please listen carefully. What is 48 section? Restriction on voting rights. Technically, this is also called as the variation in shareholders' rights. What is the section name? Variation in shareholders' rights. I will explain you the concept clearly first and then we will go into the answer. I told you through questions, now we are going into the answers. See, normally company can issue shares, equity shares. Sometimes company will go for DVR, differential voting. Yes, if you straight away say on the face, I am going to issue DVR, there is a procedure, simple procedure to be complied. See, procedure of DVR is very simple. Number one, ordinary resolution. That's it, answer over. Sir, you said big procedure. That's not a procedure. That's a check on your character. Okay, that take hardly 1 minute time. Did you have default to know that 1 minute time? Filing 1 minute time. I wanted to know certain facts about you. That's not a procedure. Procedure na very simple. What is the procedure? Number one, articles. Number two, ordinary resolution. Number three, check the voting percentage. The voting power of the DVR should not exceed 75% of the total voting power. These three conditions. Therefore, provisions are very simple. Procedure is very simple when you go for a DVR issue. Okay, logical, na? So, what crime I am doing? I am issuing DVR shares. But I will check your character in the past. Okay, different kinds. Filing default, subsisting default, 5-year default, 3-year default. Like that, they have checked 4 kinds of default. Are you not covered by any of these? Yes, you are clean. Come and issue DVR. Procedure over. Hello, I'm talking to you. Everyone understood or not? Understood, everyone? Okay, now listen. But sometimes companies behave very rudely. They will issue shares like a normal equity share. Somewhere in the middle of existence, 3-4 years after, they will tell, we are going to convert them into DVR. And originally issued as a normal share, now converted into DVR. This is big issue to discuss. That's why this question came. See, whenever company wanted to vary the shareholders' rights, okay, voting rights, if they wanted to vary somewhere in the middle, not from the beginning, then 48 will get applied. Number one, three conditions you need to satisfy. There should be a provision in memorandum or articles. Okay, not memorandum of, memorandum or articles. Okay, so either memorandum or article should contain such right to vary, or the terms of issue of the share of the class is not prohibiting such variation. Sorry, I did not understand. See, I wanted to vary the shareholders' right somewhere in the middle. First, to go into memorandum and check whether you have a right like that. No, na. Go to the articles and check whether you have a right. No, na. If yes, na, very good. Go for variation. First, proceed. No. Memorandum no. Articles also no. Can na, cannot, can. When the shares are issued, na, issue of shares is a contract. Issue of shares is in writing. In that terms and conditions sheet, clearly we mentioned that these shares can't be varied after issue. Then you cannot go for the variation shareholders' rights. Understood? So therefore, what is the point? Three options are given. Check memorandum. Yes, sir. Proceed. So no, sir. Check AOA. Yes, sir. Proceed. No, at least check the terms and conditions of issue of that equity shares long back. It was issued 5 years back. At the time of issue, we said that this can be varied. This can be varied, or nothing was said. Silent. Silence also okay. But expressly the terms and conditions prohibited variation. Then you cannot go for variation. So terms and conditions are of two types. Positive means what? Said that you can go for vary. Next one is a silence. Not saying yes, not saying no. Third one is prohibiting. Memorandum no. Articles no. Terms and conditions positive. Go. Then you can do. Silence. Even then you can do. Prohibit. Then you cannot do. Everybody understood up to here clearly? Everybody understood the concept clearly? Okay. Yeah. So next, at least 75% of the issued shares of the class must have given their consent. See, there are three classes of equity shareholders. Okay, equity shareholder class 1, class 2, class 3. Sir, class means nothing but different par values. Okay, I wanted to vary the rights of any one class. That class, 75% of the shareholders illa. Shareholders holding 75% capital. 70% capital. For example, 1 lakh shares are there. How many lakhs? 1 lakh shares are there. 1 lakh shares are held by 100 members. Okay, 100 members. In this, 10 members are holding 80,000 shares. What does it mean? These 10 members are holding 80% of the shares or not. If these 10 members give consent, that is enough. It's not 75% of the members. Equity shareholders holding 75% of the issued shares. Okay, sir, 1 lakh shares, okay, 100 people, sir. That means we need to take the approval of this 10%, sir. Yes, take it. See, second example. My company is Reliance Industries Limited. My company is Reliance Industries Limited. There are totally 1 crore shares. Example, there are 65 lakhs. Let's say 1 crore shares. My company has 1 crore shares. There are totally 7 lakh shareholders. Okay, 7 lakh shareholders. Now listen carefully. Listen. 7 lakh shareholders. Now what you said, 75% of the shares, and 75 lakh shares. 75 lakh shares are held by 4,90,000 shareholders. Okay. Going to each one of them, Ayya, give approval. Ayya, give approval. Amma, Tai, give approval. Means company has to beg, na? It becomes very difficult for the company. Therefore, do one thing. If it is impractical for the company to go in person to each and everyone and take approval, then don't go for this 75% approval. conduct a general meeting, ask shareholders to come there, pass a special resolution. So you have two options. Option number one, either obtain the approval of shareholders holding 75% capital. If it is a small company, now that will be easy rather than conducting a general meeting. If it's a very big company where the number of shareholders are in lakhs, at that time taking one-on-one approval becomes difficult. Then ask them to come to general meeting, conduct a general meeting, pass a special resolution, conclude the matter. That's the second one. That's why or endilla or. Okay. Next, after that, if variation of one class is affecting another class, why? Don't ask any question. This is not a time to learn about the background behind that. Regular class I will tell that. Just listen. If variation of one class is affecting another class of shareholders, you should also obtain approval of that other class. Okay. Next. See, whenever you pass a special resolution, 75% has to give the approval. Understanding sake. Or even you have to go for 75% voting shares approval. Who are that balance 25? Those who do not approve. Those who do not approve. For example, 90% approved, 10% did not. Okay, 91% approved, 9% did not. 75% approved, 25 did not. Did not, I said, nah, those people can file a complaint in the court, I mean tribunal. But that percentage of no should be with at least 10% of the shares. See, 1 lakh shares are held by 100 people in our example. Okay, 1 lakh shares are held by 100 shareholders. In that, 80 are holding 80,000 shares. And the balance 20 people are holding 20,000 shares or not. And 20% they are holding or not. Though 75% approval came, this 20% shareholders can go to NCLT and file a complaint saying that, sir, variation they are doing, but it is unfair, sir. Stop it. They can ask for cancellation of variation. Holders of at least 10% of the shares of the class who did not consent or vote in favor may apply to the tribunal, and variation shall not take effect unless it is confirmed by tribunal. So unless the tribunal gives any order saying yes, variation will not come into real life existence. This is all about section number 48. Everybody, are you confident and understanding all the concepts clearly or not? Okay. Okay. So 2 concepts I will cover and then I will give you a break. I can understand. 2 concepts I will cover and then I will give a break to you. Before that, please see here. Main questions only I will cover. I will not unnecessarily take a lot of time by covering unnecessary questions. Now listen. Important question. Listen. This is on transfer and transmission of shares. A company refuses to register transfer of shares made by X to Y. X transfer shares to Y, but company is not registering this transfer. The company does not even send a notice of refusal to Mr. X or Y, respectively, within the prescribed period. Has the aggrieved party, means the person who is hurt, any rights against the company for such refusal? Advise as per the provisions. Again, another expected question. Transmission is always my favorite area in share capital chapter, because no student will read. They will obviously ask questions in exam. You will get clean bold. That's what institute want. Okay, listen. See, listen carefully. See the screen. I will just write the basic provision. Provision, when I am writing now, put your 100% efforts and concentration understanding it first. There are 2 persons, X and Y. X is the transferor, Y is the transferee. X transferred shares, Y will pay consideration for that. But the transfer should happen through a legal form or not. Therefore, SH4 is the form. IOT, instrument of transfer, executed. Executed means what? Signed. Signed by both X and Y. X is consenting to sell, Y is consenting to buy. Both have to sign. From the date of executing this deed, within 60 days, you need to send it to the company for registration. Okay. Once you send it for registration, company has to register that within a time period. You should send within 60 days. Company has to take some time and register. Okay, if it is refusing the register, company must send a notice to the transferor and transferee saying that transferee and transferor saying that your transfer has been refused along with the reasons. I'm repeating very slowly. Whenever transfer happens, it should be executed through a share transfer deed or instrument of transfer in SH4. Transfer it to the company within 60 days of executing the deed for registration. Company has to register that within a time period. Within time period, it should either register or if it want to refuse it. But tell the reasons why you are refusing within a particular time period. If you do not send a refusal, why you are refusing it? The person will get a right to go for a aggrieved party. Means why? Generally, will go for appeal to the NCLT. Okay, here the problem is not about going to appeal. Time limit student has to remember. See, if a public company without sufficient cause refuses to register the transfer of securities within a period of 30 days from the date on which IOT is delivered to company. See, 60 days I should transfer na. Next 30 days ki they should register that. The transferee may, ante why? Within a period of 60 days from such refusal. If you refuse na, see, listen, 60 days time I should send. Next 30 days ki company has to register. If it does not register, na, at least it should send me refusal notice. If it send refusal notice, na, 60 days of refusal. If it refuses, from the date 60 days. If it do not send any notice, yes to no, they did not send. Within 90 days from the date of delivery of instrument of transfer. Okay, from the date on which it was delivered to the company, from that date, 90 days, appeal to tribunal. So, see, I will send within 60 days. You should register within 90 days. And 30 days time is given. 30 days time is given. By this date, it send a refusal notice. From this date within 60 days, okay, see, that's what he has given. 60 days, go to NCLT. Asal refusal notice I did not receive. 90 days completed. From the date on which you delivered. From there, within 90 days, go to NCLT. Go to NCLT directly. Go for an appeal. So if refusal notice is received, from there 60 days appeal. Notice is not given. From delivery 90 days, go to the appeal. Okay. What tribunal will do? Tribunal will hear the parties. Both X, Y, it will listen. Okay. And the company also it will listen. Why is the person who made a complaint to tribunal? Why? Company. Court will ask both the people. Are why? What is your problem? Are company, why you did not register the transfer? Argument will go on between them. Finally, if court say that Y is right, transferee is right, direct that transfer or transmission shall be registered by the company within 10 days. So it will warn the company, are company, already you did enough nonsense, register that within 10 days. Okay. Not only that, you made a delay, company made a delay by not transferring the shares. Na? Because of that, if Y incurred any damages, company should also pay the damages. That's it. Everybody understood the transfer transmission concept clearly. Hello, I am talking to you all. Understood? May 2018. Now everybody should tell this answer. Harsh purchased 1000 shares of Singhania Limited from Pratik and sent to those shares to the company for transfer in his name. The company neither transferred the shares nor sent any notice of refusal within the stipulated period. What is the time frame within which company is supposed to reply? What remedy is against the company of not sending any intimation? Everyone, please put a message there. Singhania Limited means it's a public limited company. Okay, I want 3 answers from you. See, what is the time limit for sending the IOT to company? Okay, what is the time limit for company to register the transfer? What is the time limit for appeal if company gave a notice. What is the time limit for appeal if company do not give a notice? Everyone, whoever is in live, 250 students are standing live. I should get reply from everyone. You should write like this: 20, 25, 30, 35. I'm not giving any answer, but you can't cheat me, okay? You give right dates. Okay, time limits you have to write. Everyone, write down. That's the assignment question for you now. Four questions I asked. With commas, you should write. I will wait for your answer. Everyone participate. Very nice, very nice. Almost everyone is participating. Very, very happy for taking my word so seriously. That's for your benefit only. You will pass the exam. If question comes now, flow will come just like that for you. Okay. See, instrument of transfer to the company is 60 days. Company to register 30 days. Okay. Appeal if the notice is given 60 days. If the notice itself is not given within 90 days. 60, 30, 60, 90 is the right answer. 60, 30, 60, 90 is the right answer. 60 days for IoT to company delivery. Okay. Company registers, it has to register within 30 days. Or else at least send a notice of refusal. If you send a notice of refusal from that date, 60 days, I will go to appeal to NCLT. No notice is given from the date of delivery. Within 90 days, I will go to an appeal to the tribunal. Once I go to the tribunal, tribunal will hear both the parties, direct the transfer to be made in favor of the transferee within next 10 days and also pay damages. Answer completed. 4 marks. Everyone put one yes. Are you confident about transfer question now? That's it. Right, transfer, there is only one important question. That one important question is this only. That's why it's getting repeated. Everyone, are you confident? Okay, perfect. Next. Buyback. Next one is what? Buyback. Buyback, so many, 20 attempts it came. We are not going to read buyback now. We are going to read prohibitions on buyback and then take a break. Okay, and then take a break. Sir, if I extend by another half an hour or 40 minutes like that to complete, is it okay for you? If I extend by half an hour or 40 minutes like that to cover more syllabus, is it okay for you, everyone? Sir, big chapters I told na, set A, set B, set C recently. Big chapters if you cover na, sir, confidence will come. See, now if you cover share capital chapter, the biggest chapter in companies act will be completed live. Like the big chapters, sir. Small chapters anyway you can read. The big chapters we have to complete here. Okay. So please stay live. So if you stay in live, you can do all these things. Okay. If you are not staying live now, the problem is after the session, if you listen, someone will call you, someone will do something. That flow will never come. That procrastination is spoiling your entire attempt. Okay. So please don't want that. I don't want that to happen. That's why I'm always urging stay live, stay live, stay live. Because if you don't stay live now, that seriousness will never come. You will skip, listen for 10 minutes, stop, listen for 10 minutes, stop. Now, along with you, there are 250 students sitting along with you. See how magical it will be. How many serious students are there? So take that spirit properly. The main problem with the CS students in exams is consistency in preparation. It's not that they are not efficient. If they are not efficient, how everyone will give answer, how everyone will ask the doubts, how that participation will be there. Failure doesn't come from inefficiency, it comes from inconsistency. We will read for 1 hour break, half an hour break, 10 minutes break. That's why I will always recommend attend live. Live 260 join means big number, small number leave. That 260 max 10 plus 10 minus only accepted. Because of emergency reasons, some may leave. But more than that is unacceptable. Yeah, you are not serious enough to write the exam. Okay, so take my words in a positive note, like a brotherly affection. I'm telling you, when you are not serious in the attempt, now you can't even claim a success. Success comes only when you are extremely serious about what you are doing and dedicated. Kaushik Mukesh is always a successful faculty. I will always proudly tell, yes, there is no faculty like Kaushik Mukesh. Why? We put efforts, result will come. You will not put efforts, how result will come? Correct? Huh? That always in a dedication. The work you are doing, put your 100%. Rest of the things he will take care. Nature will always take care. You do your efforts properly. 4 hours to 5 hour session or 5.5 hours. I will take 6 hours. Yeah, you should 6 hours because the session is for your benefit. Na? If I read all these questions, what I will get? Will the institute give any 1 lakh salary extra to me? No, they don't give. I should shout na morning 5 till 9 o'clock. I am having sessions. I am recording direct access parallelly. Morning I have to wake up at 5 o'clock and come to the studio. Na? It is painful also to me. And moreover, we are charging anything. It's a free YouTube live. More people should get the benefit. More people, thousands of people, lakhs of students should get benefited out of it. Same like this we will do for FM. Next attempt onwards we will do for DT. Why success will not come? That's it. Simple logic. Yeah. Directly proportional. Efforts and success. Right efforts and super success is always directly proportional. If you put this much of right effort, you will get this much of success. That's it. So remember properly. Okay. So now listen. Buyback prohibition we will read. And then we will take a break for half an hour and come back. And do till we complete share capital and we complete LLP and dividends chapter. After share capital, I will take a small chapter called as the dividends. Then I will go to LLP. Okay. So let's see. Company cannot go for buyback. Under what circumstances company cannot go for buyback? See. Company buyback has to be done directly, not through its subsidiaries. Okay. Not through its subsidiaries. Means what? Companies cannot go for buyback. Companies cannot go for buyback. Means what? Company cannot go for buyback either directly or even indirectly through its subsidiaries. Okay. So that's why company should not directly or indirectly purchase its own shares or specified securities through any subsidiary or through any investment company. Sir, what does it mean? There is a company called as X Limited. Okay. There is a company called as X Limited. X Limited cannot purchase its own shares unless and until they comply with a lengthy procedure set in 68. Some companies wanted to escape this route. Do you know what they will do? X Limited will go to HDFC Mutual Fund. It will ask this HDFC Mutual Fund, HDFC Mutual Fund, I will give you 1 crore. Okay. You purchase the shares of X Limited. Then what will happen? Indirectly, X Limited is purchasing the shares of X Limited through a mutual fund called as investment company. This also is not valid. Means in the middle you can't keep subsidiary. In the middle you can't keep mutual fund also. Everybody understood or not? Everybody understood or not? Next. During subsistence, continuance of default in. That means when these are in default, you cannot go for buyback. What default? Repayment of deposits or interest. So, principal, interest on deposits. Principal on debentures. Principal on debentures. Principal on preference shares. Dividend payment. Term loan, interest on any financial institution or bank. Simply financial defaults if you have. Which default? Financial defaults if you have. You cannot go for buyback. Buyback means what? When you have excess profits, you will go for buyback. When you have that much excess profit, First pay what you need to pay obligatory. Array payment to equity shareholders is extremely optional. When obligations you are not paying, how dare you go for an optional thing? Therefore, lawmaker is extremely clear. Deposits matured but not paid, first pay them. Debentures matured but not paid, first pay them. Interest not paid, first pay them. Preferences came up for redemption not redeemed, first redeem them. And next one, term loan not paid, first pay that. Anything if you don't pay, first pay that. Okay. Next, same like DVR. Provided that buyback is not prohibited, if the default is remedied and a period of 3 years has been elapsed, after such a default ceased to subsist. It's not end of financial year. Today you cleared the default. Today you cleared the default. From today count 3 years. That's why they did not use the word 3 financial years. From today, for example, 26 July, I remedy the default. I made the default good. From today, 3 years you have to count. 26 July 2026, 27, 28. Or from 27th July 2028 onwards, you can go for buyback. Okay, next. Non-compliance of filing annual return. Until annual return you did not file. Declaration of dividend non-compliance. Or distribution of declared dividend. In that you made a default. Time limit you made a default. Or financial statement not filed. In this case, company cannot go for buyback. Okay. See, in this question, what they asked. Messrs. Gromor Pharma Limited is planning to buyback of its shares during the current year, but the company has defaulted in payment of term loan or interest on its bankers. Tell me, if there is a term loan or interest on banking companies, if there is a default, what will happen? Company cannot go for a buyback for a period of 3 years, not from default date, from the date on which the default is made good. For 3 years after the date, still prohibition will apply. After that, company can go for buyback. Conclusion. Buyback is not prohibited if the default is remedied and a period of 3 years has been allowed. Both conditions, remedied and 3 years. Thus, Messrs. Gromor Pharma can go for buyback on its own shares 3 years after it has been remedied its fault in non-payment of term loan and interest to the bankers. Understood? Okay. Now, next, November 2016, conditions for buyback is there. That we will see after a break for half an hour. Okay. Take a break for half an hour. It's around 8:15 now. 8:45. Okay. We will again resume our class. Those who miss the introduction or anything today, during the break you complete. That's a punishment for you. Complete it such that you will come on par with all the students. Okay. So do that and come. We are going to first complete another 20 questions in share capital. I am not going to repeat the questions. Again, there is a question on buyback. We don't read. New questions, if there is any, we will first complete and then we will be going into the next area. Okay. Big chapters take time like this. Dividends chapter na football. Just 1 hour will complete entire dividends. Take a break and come. Can we resume the class, everyone? Everyone join fast. So many people had to join. Another 2 minutes I will wait for you and I will start with buyback. So in the meanwhile, if anyone want, you can just go to buyback section and read. You can go to buyback section number 68 and read the contents of buyback before reading the question. Come fast. I said 8:45, it's almost about 9. 3 minutes to 9. 9 exactly I will start irrespective of the number of students present here. One more minute. Let's begin. It's 9. So let us continue. We are now going into the next concept in the share capital chapter, buyback. Okay. So let us start with the buyback concept. One single question which covers all the concept of buyback. I am going to cover such a questions as that. Repeated questions, if any, you can read. Main question, the concept will be explained in this. Okay. See. Yeah. Nothing here. I'm just checking. My live is only going on. Whether everything is right or not, I'm checking. I'm not watching any movie. So listen. XYZ Company Limited at a general meeting of its members of the company pass an ordinary resolution to buy back 30% of its equity share capital. Articles of the company empower the company for buyback of equity shares. Company further decides that payment for the buyback to be made out of proceeds of company's earlier issue of equity shares. Profits of company's earlier issue of equity shares. Explain the provisions stating the sources through which buyback of the company own shares can be executed. Whether company's proposal is in order, whether your answer will be same, even instead of 30%, company buyback only 20% of its equity share capital. Okay. First of all, listen carefully. Company wanted to buy back 30% of its equity share capital. First question is 30% is allowed or not is a question number 1. How to present your answer? Always learn. First write down what is said in the section, Bear Act or provision you call. Under section 68, first you have to quote the position of law. A company can purchase its own shares, okay, by following the conditions subject to the limits and procedures. Number 1. Next question. What sources can be made available to make a buyback? Buyback can be made out of 3 sources. Free reserves, securities premium account, and proceeds of issue of any shares or specified securities. Specified securities means you can also make a issue of shares to buy back the existing shares. You can also do like that. Okay. Proceeds of issue of shares. Okay. So what he said, buyback of any kind of shares or other special securities cannot be made out of proceeds of an earlier issue of same kind of shares or same kind of other securities. Means what? This is called as a fresh issue, not existing issue. Okay. For example, there are 3 classes of shares: class 1, class 2, class 3. Class 1 money I wanted to buy back class 2. Not allowed. Allowed or not allowed? Not allowed. Are you understanding? You have to make a fresh issue. Money will come. Through that you can buy back. From the earlier issue, you cannot make. So the first question. Okay. First question. Company decides to make the payment of buyback out of the proceeds of company's earlier issue. Not allowed. Out of the proceeds of fresh issue only they have to do that. Next. So what are the 3 sources? Free reserves, securities premium, fresh issue of shares. Next. Requirements for buyback. First one. In order to go for a buyback, articles of association shall provide for the same. If articles is silent, alter the articles, add the buyback into that, then go for buyback. Next one. Whenever we say buyback, generally special resolution is required. What is required? Special resolution passed at a general meeting. However, special resolution is not required in one case. When if the buyback amount BBA means what? Bachelor in Business Administration. Illa. Buyback amount. If the buyback amount is not more than 10%. Hey, wait, pen is not working. Okay. So buyback amount do not exceed 10% of, okay, paid up equity share capital plus free reserves. Okay. If the BBA buyback amount does not exceed 10% of paid up equity capital plus free reserves. Take the paid up equity capital plus the free reserves. It does not exceed 10% of that. Then special resolution not required. Board resolution is enough. Along with that, you need to satisfy this particular condition. So in simple language, board resolution plus amount not exceeding 10% of paid up share capital plus free reserves, then special resolution is not required. But here if you observe clearly in the question, they said 30% of its equity shares. Means what? Paid up capital on it is 30%. You need not even add free reserves. So this is allowed or not allowed? Allowed or not allowed are different. Special resolution has to be passed. But in the given case, they passed which resolution? Ordinary resolution. See now. Next. Now let us see the buyback limit. What is the maximum limit to go for a buyback? Mark my points very importantly. 2 points I am going to discuss here. Buyback for a financial year, buyback for a life. Means what? In the life of a company itself, okay, in the life of the company itself, buyback should not exceed 25% of paid up share capital and free reserves. Here paid up equity capital, here all the share capital plus free reserves. Understood my point or not? Okay. Next, buyback limit for one financial year. Buyback limit for one financial year. If you wanted to go for a buyback for one financial year, that buyback amount shall not exceed 25% of paid up equity share capital in that financial year. 3 limits I told you now. 3 limits that they will play football. So in the notes you write down buyback limits. Buyback limits. Number 1. Limit up to which board resolution is enough. Yes sir, not required. Buyback amount does not exceed 10% of equity share capital plus free reserves. Okay. Number 2. Okay, wow. Number 2. Second. So limit up to which board resolution is enough. That's the point number 1. Number 2. Buyback should not exceed that financial year. Free reserves. Okay. Next, for the purposes of this section, wherever free reserves is used, include also securities premium into that. Normally securities premium don't include into free reserve. For the purposes of this section, we will consider securities premium also to be included in the free reserves. Have you written? Everyone, have you written? Okay. Because if you see, there is a section called as section number Listen. There is a section called as section number 52. Okay, utilization of securities premium. In that utilization of securities premium, you will see buyback. Securities premium is a capital profit. Buyback is a capital outflow. Securities premium is a capital inflow. Because at the time of issue of shares, you are getting a premium on capital. It's a capital receipt. Buyback is a capital expenditure. So this capital receipt can be used to pay this capital expenditure. That's the logic. This is the answer for the question raised by Abhishek. Don't think that I am not seeing your questions. Okay. This is a question and the answer for Abhishek Aditya J. Why, sir? This is the reason why. Hello, everyone. Have you noted all the 3 points or not? We'll go to the next part. We completed prohibition. We completed some procedure as well. Everyone, can I proceed? Yeah. So those who have to join, please join fast. Stay consistent till we complete the session. I can't guarantee 10 o'clock. It can be more also. Our target is to complete our targets. Okay. So now, next condition. Debt equity ratio should not exceed 2:1. Means what? The total of the debts should not exceed twice the paid up share capital and free reserves. Should not exceed twice the paid up share capital and free reserves. Means 1 rupee equity in a debt can be maximum 2. It should not be more than 2. Next. Buyback shares must be fully paid up shares, not partly paid up. If it is a listed company, follow also SEBI regulations. Okay. That's it. And the entire no offer. For example, now you went for a buyback. No offer for buyback shall be made within a period of 1 year. Simply to tell, if you go for buyback now, within next 1 year, you should again not go for any kind of buyback. Okay. So you can go for buyback in 3 ways. Number 1, you can make a buyback out of free reserves. Securities premium, fresh issue of shares. Which issue? Fresh issue of shares means issue new shares, get the money, buy back them, pay them, send them out. Are you understanding or not? This is the way they will do. Means when cost of equity, KE, of a particular class of equity shareholders is very high, burdensome to the company, they will send them out. They will only welcome the new people into the company. Everybody understood the point clearly or not? Everyone? Can we go to the next one? Yeah. So, present case. Articles authorized members by ordinary resolution. However, resolution required is special resolution. Buyback approved is 30%. Maximum limit is only 25%. Maximum limit is 25. One financial, it should not exceed 25% of the total paid up equity capital of that company. Conclusion. Company proposal to buyback is not in order and it has passed only ordinary resolution and not a special resolution. Okay. That's the answer. Next question. Question number 15, May 2017. Let's see. ABC Company Limited is holding 46% of total equity shares in SVS Company Limited. The board of directors of SVS Company Limited incorporated on Jan 1st, 2014 decides to raise the share capital by issuing further shares. Board of directors resolved not to offer any shares to ABC Company Limited on the ground that it was already holding a high percentage of total number of shares already issued in SVS Company Limited. Articles of Association of SVS Company Limited provides that new shares be offered to the existing shareholders of the company. On March 1st, 2014, new shares were issued to all existing shareholders except ABC Company Limited. Referring to the provisions of Companies Act, examine the validity of the decision of the Board of Directors of SVS Company Limited of not offering any further shares to ABC Company Limited. This is the section on Section 61, subsection 1, Clause A, subclause number 1, 2, 3. This is the section quoted. Section 62, subsection number 1, class A, subclass 1, subclass 2, subclass 3, proviso, explanation. All these things we need to understand this. Okay. First, take your time, read it properly. Then we'll go into the discussion part. Take minute time, 1 minute. Okay. Only I will give you 1 minute time. Read the question properly. Presence of mind, please. These questions will come in exam. The question for Amarnath, yes, your question is right. You cannot issue the same class. Shall I continue with the answer? Everyone, shall I continue with the answer? Reply. Reply, everyone. Yeah, see now. So how to answer this particular question for buyback? Okay, whenever company wanted to go for a buyback, then how to do it? We already read. Now we are coming into the rights issue. Listen carefully, I will explain in just in 2 minutes the idea behind. Whenever company wanted to go for further issue of shares, okay, first option should be given to the existing equity shareholders. To whom? Yeah, existing equity shareholders. I will tell the procedure said in section 62, subsection 1, class A, subclass 1, subclass 2, subclass 3. What is said in the Bear Act? I will try to tell in a simplified English language. Try to listen. Number 1, whenever company wanted to go for a rights offer, simply to tell further issue of subscribed capital, further issue of subscribed capital. See, I will give you an example. Buyback increases the issued share capital. Okay, buyback increases issued share capital. Means no subscription, no calling up, no paying up. Directly add to the issued capital. Understood our point or not? See, there is a difference between further issue of shares and by bonus shares. Reason is, in a bonus share, subscribed capital won't grow. Directly issued capital will grow. Understood? Honestly, you tell me, honestly, when I say honestly, honestly you should tell. Okay? Don't tell any lie. Honestly, you tell. Do you know that the difference between rights offer and bonus issue is subscribed capital and issued capital? Raise of issued capital is bonus issue. Raise of subscribed capital is rights issue. Tell how many of you know? Honestly. See, sir, again and again I'm telling you, Companies Act is like, what is this? It is something like mine. Go on digging it. Okay. You will get so many new things to learn. Okay. I told in the class. How many of you remember this? I will not tell. I will tell. See, I will show you one example for you to understand. See here. See here, everyone. I want every one of you observe. We are in section 62, subsection 1, class A, subclass 1, subclass 2, subclass 3. Now you can believe me, na? I'm not telling anything, sarda. No, fact. Section 62, subsection 1, class A, subclass 1, subclass 2, subclass 3. Those we are going to read. Where at any time company having share capital proposes to increase its subscribed capital per per subscribed capital, not issued capital. Company may issue fully paid up shares. Per da. This is issued, issuing. There is no subscribing, there is no calling, there is no paying. But rights offer, you have to subscribe, company will call, you have to pay. There is a subscription model. Understood? Hello, I'm talking to you, everyone. So the point is, know the difference first, then you can become expert. Okay, first know what is happening in the sections. Rights offer will always happen on subscription basis. Further issue of capital happens on subscription basis. But bonus issue is not made on subscription basis. Directly, company will add it to the issued capital. That's it. No calling up, no subscribing, no calling, no paying. Directly issue. But rights, subscription, after that call, after that pay, unpaid shares, paid calls in arrears, advance, all this nonsense will come in normal issue of shares. Hopefully everyone now got a clarity and difference between section 62 and 63 rights and bonus. Now, listen carefully. Whenever company is going for a rights offer, first point to write in exam. Point number 1 you have to write is, company must, if the company intention is to increase subscribed share capital, then company should go for rights issue. Number 1. Number 2, whenever company is going for rights issue, section 62, subsection 1, clause A will get applied. In this, 3 points will come. 1, 2, 3. Let us see what are these 3. Okay, let us see what are these 3. Number 1, first one, point number 1. When a company will go for a rights issue, first point, rights issue when it will go, okay, offer should be given by the company to the existing shareholders of the company in proportion to paid up capital. Sir, what do you mean by in proportion to paid up capital? They will tell, we are issuing right shares in the ratio of 1:5. Means what? Proportion 1/5. For every 5 shares, 1 share I will give. That's called as a proportion. Ratio. Ratios and proportions, yeah. So, company will issue to the equity shareholders, in existing equity shareholders, in proportion to the paid up capital. In proportion to the paid up capital. What they will give? Offer letter they will give. Letter of offer they will give. Okay. Letter of offer. Recent. Just a week back, 10 days back. Shortcuts I will write in class to complete it very fast. I will just roughly scribble in the paper. Letter of offer, I don't know how to write. Letter of offer, how to write? Mind what I got? Letter of offer I have written. It became lawfer. So don't write lawfer, something like that. Letter of offer means LOOFO. Offer means letter of offer. Letter of offer represents what? It's a letter given by the company to all the existing shareholders as an offer. You can maybe accept, you may not accept also. So listen, letter of offer, you have 3 options. You can either accept, you can either decline, you can either renounce. See, acceptance or declination or renunciation should be done minimum 7 days, maximum 30 days. Minimum 7 days, maximum 30 days. Section says 15, but rules are now amended. They made it 7 days. So, letter of offer should be accepted by you. Minimum period given will be 7 days. And a company should give minimum 7 days time. Maximum it can give up to 30. And it can give 7, 8, 9, 10, 11, 12, like that. 22, 23, 24, 25, 26, 27, 28, 29, 30. Company cannot give more than 30 days time. Company cannot give less than 7 days time. Between 7 and 30, you can give in whatever time you want in that letter of offer. Understood the concept clearly? Yeah? So what I said now, offer must be given by the company to all the existing shareholders in proportion to the capital. Letter of offer, you can either accept, decline, or renounce. Renounce means transfer the offer letter to some other person. Minimum days given is 7 days. Maximum time given is 30 days. Within that time, you have to do all these things. Listen, second one, about renunciation, about renouncing. Who can renounce? The existing shareholder who received the letter of offer. Who received the letter of offer can renounce it to any person. Renounce it to any person. Okay. In whose favor he will issue the letter of offer, he will get the shares. Unless articles prohibit. Articles prohibit. Do you know what does it mean? If articles say yes, go for renunciation, go. If articles is silent, then also you can go. If articles say clearly no renunciation, then only no renunciation. Or else renunciation is by default. Renunciation is by default. Next, third point to understand. Third point to understand. See, if anyone do not accept the offer within the time period, we will assume that he has declined the offer. He has declined the offer. Board of directors will take such action on the shares belonging to that person. Okay, this point is not that important. Just remember 3 points. Whenever company goes for a rights offer, first one, company wanted to increase its subscribed share capital. Whenever subscribed share capital is wanted to increase through issue of new shares, offer should be given by the company to all existing shareholders. Not even one person they should leave. It should be given to all existing shareholders. Okay, all existing equity shareholders propose to issue in proportion to the paid up capital. Give a letter of offer. They have 3 rights: right to accept, decline, renounce. Within 7 days minimum, 30 days will be maximum. Renunciation rights. A company will give it to existing equity shareholders letter of offer. They can renounce to any person unless articles prohibit. Okay, if you do not accept within time period, it is assumed that it is declined. Okay, in the given case, what happened? Let us see. ABC Limited is holding, there is a company called as SVS. In this SVS, ABC Limited is holding 46% capital. Company wanted to raise the share capital by issuing new shares. Okay, we assume that it is subscribed capital increase. Okay, so the directors resolve not to offer any shares to ABC. Means ABC is existing shareholder. Along with ABC, another 54% shareholders are there. We have to issue to all. Board of directors decided that if we issue again to ABC, their percentage will be increasing such that SPS Limited can become their subsidiary. Na? Therefore, they said, letter of offer, let us send to everyone except to ABC. Is it right or not? They are asking. 100% wrong. Lawmaker clearly said in the Bail Act, offered to the persons who are the holders of equity shares. In that they did not tell high percentage is already there, don't give to them, remaining people you have to give. There is no such concept. Every person you should give. Final conclusion. See, first you have to tell the point. Letter of offer may be specified not less than 15 days. Now that 15 days is such a lesser number of days, that is 7 days, maximum not exceeding 30 days. If not accepted, deemed that it is declined. Unless articles otherwise provide, offer shall be deemed to include a right to renounce. Okay. Finally, ABC Limited is entitled to right of preemption. There is also a specific requirement. Thus, holding high percentage is not a valid reason for violating the provisions of 62. Therefore, decision of Board of Directors is invalid. Everyone joining live, answer me. Did you understand the concept of rights issue clearly? Everyone, did you understand the concept of rights issue clearly? Done. Next one. November 2017 question. MN Limited is engaged in manufacture of consumer goods and has got good brand value. Over the years, it has built a good reputation and its balance sheet as at 2017 shows the following. Authorized share capital, 25 lakh equity shares of 10 each, 2 crore 50 lakh. 10 lakh equity shares of face value 10, fully paid up 1 crore. Free reserves 3 crore. Board of Directors proposing to declare bonus issue for 1 share for every 2 shares held. Board wants to know the conditions for issue of bonus shares. See, remaining things aside, conditions of bonus issue I will tell you what are they. But the main provision, let us focus. See, company already have 10 lakh equity share. Company wanted to go for 1:2. Means for every 2 shares held, 1 share I will give. Already 10 lakh shares are there. Into 1/2 means how many shares? 5 lakh. And the total shares will become how much after bonus? 15. Into how much? 10. Are you understanding or not? Now it is 10 lakh shares. That will become now how many shares? 15 lakh shares it will become. Into 10 each. 1 crore 50 lakhs. It is within the authorized share capital of 2 crore 50 lakhs or not? Yes. So therefore the first answer is yes, it is allowed to go for a bonus offer. Okay. See. 1 crore paid up capital bonus issue. It is within the free reserves available. Next. How much free reserves is available? 3 crore. Bonus issue can be made out of free reserves of a company. Which reserves? Free reserves of a company. Sometimes also out of securities premium. Out of a securities premium. Let us see. Permitted by AOA. First, bonus issue must be permitted by articles of association. Next, like dividend recommended by board of directors, general meeting should resolve the capitalization of profits. You are going for bonus, means you are having excess profit. If you have that much excess profit, first to go for payment of the defaults. So therefore, no company should have, the company should have not defaulted in the payment of interest and principal in respect of fixed deposits or debt securities issued. Means your company debts you are defaulted, you are saying I am having excess profit. If you have that much excess profit, first clear your defaults. Next, no statutory dues. No statutory dues. If the company is having partly paid shares, okay, if the company is having partly paid, say 7 rupee shares are there out of 10 paid up. Okay, company wanted to issue a bonus share. Why you are issuing bonus share? Yeah, instead of issuing free of shares, convert this partly paid into fully paid. So, unless partly paid shares are made, fully paid up. So, if there are any partly paid shares in the company, first make them fully paid. Even after that, if anything is remaining, then go for a bonus issue for the balance amount. Next, not in the lieu of dividend. Whenever you declare dividend, pay dividend only in cash. Cash is not currency, bank account transfer. Understood? Asal dividend is not declared, then you can go for bonus. But once a dividend is declared, you should pay only in cash. Okay. Since in class I told you this, bonus issue can be made instead of declaring dividend, not instead of declared dividend. If dividend is declared, it must be paid only in cash. If you do not declare the dividend at all, then you can go for the bonus. Are you understanding the point or not? So if you do not even commit to declare, then go for bonus. But if you are committed to declare the dividend, you cannot go for bonus offer. Understood the point or not, everyone? Yeah. So next. Once a bonus decision is taken, withdrawal cannot be made by the board of directors. In this given case, tell me, bonus issue can be made out of free reserves. Okay, securities premium sometimes. So I have buyback of 5 lakh shares. 5 lakh into 10 rupee means 50 lakhs I need to have from free reserve. I have 3 lakh free reserve. 50 lakh I can do. And it is within the authorized capital. Since all the conditions are satisfied, by following this procedure, company can go for bonus offer. Everybody understood or not? Okay. Next. See, November 2017, this is about the concept of Diminution in value of shares. Sir, listen carefully. Every student appearing live, again I am repeating, stay live consistently. Now we are about to close this area because all important questions in the share capital I am going to cover, and I am covering in a consistent basis all important questions. Where you do the mistakes, if it is important and non-repetitive, I am covering that. Stay in contact live till we complete the session, such that when you prepare, you need not spend time. Half an hour you will complete share capital, half an hour you will get that 8 marks. Entirely up to you. Stay consistent. I am saying 100 times, again I am repeating. Stay consistent across any kind of emergency work. Nothing is more important than you and your attempt. In the light of the result that institute is giving for CA Inter, consistency, some kind of honesty in your preparation is expected. Clear, everyone? So listen carefully to what I said. Out of lot of affection towards you, I am telling you, we should not see a failure, or else once you see the failure, it becomes a habit. Motivation also will be lost after some time. Take it for granted that you have to pass. I have emergency work. Leave all emergency. The emergency which came to you will not come to your rescue when you fail in the exam. Okay? Some emergency will come. Big emergencies are there which are intolerable. Accepted. Small things at home, small emergencies, if they disturb you, when you are disturbed, those emergencies don't come for your rescue. Clear? My friend has called immediately, I need to pick up the call. Okay, some relatives came, I need to attend them. They won't come to your rescue when you fail. When paper is extremely hard to write in exam, no relative will come sit behind you and tell the answer. No emergency which stopped you today won't make you to write your paper. Okay? Keep all emergencies in the trash bin. Work for you. Work for your success. Do you understand what I said? I think everyone can understand a basic English. Okay? No one is important than you. Now, in this moment, you are important for you. Clear? So keep that in mind always. You should be important for you. After that, you think about all others. Nothing is more emergency than you. Your attempt is very big emergency at this moment. Okay? Listen carefully. Consistently listen. Next. What we are discussing now? Diminution of capital. See, A Limited has an authorized capital of 10 lakh equity shares of face value rupees 100 each. 10 lakh shares, 100 rupee each. Some of the shareholders expressed their opinion in the AGM that it is very difficult for them to trade in the shares of the company in the share market, requested the company to reduce the face value of each share to 10 and increase the number of shares to 1 crore. See, beautiful framed question. See what they are saying. Companies will go for breaking of capital, not reduction, breaking. 100 rupee par value, they will reduce to 10 rupee. 10 times there is a diminution in each share value. See, instead of giving one big share of 100, I will make it into bits and pieces of 10 rupees each. Sir, why they will do this way? Small marketing strategy. I will give you an example. If you see Coke, they will make a 2-liter bottle. They will make 1-liter bottle. They will make 300 ml bottle. They will make 250 ml bottle. Okay? Airports, if you see, they will give 200 ml small tin also. 150 or 200 ml. Small tins also they will give in airport. Lounges, you will see that. What you understand from all these? The more smaller you make, it will become accessible to more people. For example, I wanted to have Coke. Say example, I will never have. Example, if I wanted to have a Coke, why I will have 2-liter bottle? Yeah. Do I have any plan with my friends to do anything? No. Then what I will do? Why I want the 2-liter bottle? Therefore, they introduced a chota pack, small pack, or a 250 ml or something will be there. So that they will take. Why? It becomes more accessible. 2-liter Coke bottle, if 100 people buy in a day, because if 100 people buy in a day, 200 ml or 250 ml, whatever the case, I may be wrong also because I never have it. So I don't want it to have actually. So that 200 or 250 ml, whatever small packs will be then a small bottles, those 1 lakh people will have every day. Rather than targeting on 1000 having big one, concentrate on 1 lakh having small one. Accessibility to the market will increase. Same logic also for the shares. My share price is very big, means you are a good company. Yeah? Illa. See, for example, MRF is there. MRF share price will be in lakhs. Do you think MRF is a big company? It's one of the smallest companies. It's not even there in Nifty. Nifty 50 MRF is not there. So 1 lakh, sir, highest share price, it should come into Nifty now. It will not. People don't trade on MRF shares. MRF shares will be out of the purview of so many Indian people. How people will think MRF share price 1,20,000. Rather than purchasing MRF share with 1,20,000, I can purchase 20 different shares. Understood the point or not? Then why I will unnecessarily go to that bloody MRF company? I will not go. Force Motors also same. Force Motors also same. 14,000, 15,000 is the share price. The last traded price somewhere around 14,600. Who will pay? India. You give share at 2,000, 1,500, 300. Lakhs of people will come forward. Okay. Same strategy was used by Infosys in the year 2017. Do you know what Infosys have done? Infosys share price once upon a time used to be somewhere around 4,500 rupees. They made split into 1:3. Means what? Every one share will get split into 3 parts. Okay, split into 3 parts. So every share is split into 3 parts. Therefore, what will happen? For 4,500 share will come down to 1,500 rupees. Persons who are not interested to buy Infosys shares before because of high pricing will now come forward to buy. Demand for the shares will increase. Understood the point or not? It's the concept behind the diminution. That's what happened in this company. See, shareholders expressed their opinion in the AGM that it is very difficult for them to trade the shares of the company in the share market and requested company to reduce the face value. Face value reduced, automatically market value also proportionally reduced. See, can we do like that or not? A company having a share capital, if so authorized by AOA, alter its MOA in its general meeting to subdivide its shares. Okay, first articles of power should be there. After that, first as per the memorandum, you should subdivide your shares into shares of a smaller amount. 100 rupee share, 10 rupee shares of 10 each into smaller amount. Then is fixed by MOA. MOA, what is written in the authorized share capital? See, I will erase this. Read. MOA, what is written? 10 lakh equity shares of rupees 100 each. Authorized share capital. Memorandum 6 clauses are there. Name, situation, objects, liability, capital. And the capital clause, what is the first one? Authorized capital. That authorized capital originally have 10 lakh. Now I am subdividing into how much? Subdividing into 10 parts. So 10 lakh shares will become how many shares? 1 crore. Therefore, in memorandum previously 10 lakh is there. I need to alter authorized or not. Therefore, alter its MOA. First condition number 1. AOA power should be there to subdivide. Second one, alter your MOA. Alter your MOA. So first condition, AOA to provide. Alter the MOA. Very good. Then go for subdivision in a proportion, means ratio 1:5, 1:10, like that. Clear? Next. In the light of above provision, the request of the shareholders is possible. Company shall alter MOA in its general meeting. It shall file with ROC form SH7 within 30 days of its alteration. This you have to remember. Yeah. How can I make you to learn this? This you have to remember. So whenever there is a authorized capital change, form SH7 you have to file within 30 days of above alteration. Understood the point clearly? Everyone understood the point clearly? Done. See, this question is for students. Now you people will tell the answer. Honesty is the key for everything. Read question as it is. 2 minutes time. I want answer for question 1, question 2. Don't tell procedure. Final answer you give me. See the question. 2 minutes time. 2 minutes time to read the question. 1 minute time to give the answer. In the comments box, I should get 2 answers from you. Whether company can go for a bonus ratio 1:3, whether it can go for 1:2. Your answer should be yes, comma, no, or yes, comma, yes, no, comma, yes, no, comma, no. First of all, everyone put a message. Are you all doing it? Put a message, yes, sir. Are you all doing the question? Super, super. Do it. One minute for you to answer. Start answering. Done. Time up. Time up. Time up. Stop. Stop answering. Stop answering. Okay. See here now. Now the question. Sir, canna, cannot is a question. Simple question. For that most simple answer. Exam lo question come like this na. Safest method to present the answer. First write down the provision. For that at least they will give you, this is a 6 marks question. At least they will give you 4 marks for the writing of answer. Means what? Bonus issue should be authorized by articles. Bonus issue require recommendation of board of directors and approval of shareholders in a general meeting by passing ordinary resolution. Bonus issue can be made instead of declaring the dividend. Fully paid up shares. No default in the debts relating to the fixed deposits and debentures issued by the company debt securities. No default in statutory dues. Okay. And shares must be fully paid. Like that, write down the remaining full part. Further, they will first give you the mark. That's how the secret to present a smart answer. Even though you are confused in conclusion, first write the provision properly. Further, they will give you the marks. Okay. Next. Now, what are the sources of bonus issue? That's the point. Correct? See, free reserves can be used. What can be used? Free reserves can be used. Next. Sir, can they use securities premium? Yes. Who said? See. Doubts should not come here. Certain things you should not get a doubt at all. application of security premium. Section 52. Towards bonus shares. Towards bonus shares. Securities premium. Hey, don't mug up, yeah. See, simple concept, na? See here. Securities premium is a capital receipt. Bonus issue is like a capital spending. So capital can be used to capital spending. Dividend is a revenue spending. It's not a capital spending. That's why securities premium being a capital receipt can't be used to pay the dividend because it's a revenue, it's a capital nature. Understood or not? Why they kept the section like that? Securities premium. Okay. So now I can use a free reserve for bonus. I can use securities premium for bonus. That CRR, can I use that? Yes. CRR is created at the time you go for buyback. Whenever company go for buyback, out of free reserves and securities premium, then nominal value of the shares bought back will be transferred to CRR. That CRR can be utilized only for the purpose of fully paid up bonus shares. So this also can be used. 5, 3, 4. 88 plus 4, 12. So 12 lakhs I can use here. Okay. 1:3 means 10 lakhs I can make. So 12 lakhs is available. Do it. Okay. 1:2 means 15 lakhs I have to do, but only 12 lakhs available. You cannot do. Answer is yes and no. Final answer. First 12 lakh. Next 15 lakh. Second one cannot. First one can. Answer is completed. See how easy if you learn the concept. Hello, everybody. So, but see how answer is presented. Don't directly conclude your answers with yes, no. In comments box, you can put yes, no. But like that in exam, yes, comma, no. If you write na, they will write no. So therefore, don't do that. Exam la first write down the provision, such that even though your conclusion is wrong, for the provision they will give the mark because you are having a stepwise marking. Next. This is again on 62 section. Important. Very, very important question came. Expected again for the exams. Expected for the exam. Okay. Expected for the exam. What is the section? Okay. Any doubts from the students? Are FM marathon will be there or old one should we watch? No. FM marathon also will be there. Where level it will be there. August 5th onwards, FM marathon will be there. August 5th. 5th onwards, marathon will start for FM. Okay. Now we are doing law marathon. Next day, FM marathon will start from 5th of August for 3 days. Same. 2 chapters a day. 6 chapters will cover there. Sorry, anyway. See here. Question number 23. See here. Heavy Metals Limited wants to provide financial assistance to its employees to enable them to subscribe certain number of fully paid shares. Considering the provisions of Companies Act, advise whether company in this regard. See, what they wanted to do, just now we discussed one point. Company should not buy back its shares indirectly. It should follow the procedure of section 68 to do a buyback. This is what we already learned. Correct? Company will do this way. Company will raise capital. Okay. From public. From public. Money came. I wanted to pay them again. What company will do? Company will do like this. It uses its own money to pay them back. Using the free reserves, they pay back the capital. Then what we tell, not allowed. Unless and until you comply with 68 section, big procedure. Therefore, what companies will smartly do? Companies will use these reserves, which is in the form of cash on the assets side. give to its employees as a loan. Loan again comes, loan given, not taken, asset side. Okay, loan will be given to employees. These employees will invest in the capital of this company. And indirectly, what is happening? Company's money is used to buy the shares of company itself. May not be purchased by company directly, but by employees of the company, it is purchased or not. It is generally not allowed, but it is allowed if some conditions are satisfied. See, as per section 67(2) of Companies Act, no public company is allowed to give directly or indirectly, whether by loan, guarantee, security, any financial assistance for the purpose in connection with purchase or subscription by any person of the shares or its holding company. So you should not give loan to any person to purchase the shares of your own company. This is normal provision, but there is an exception. What is the exception? Companies can give loans to their employees. They can give loan to their employees. Loan to their employees. Other than directors and KMP. Sir, why sir I can't give loan to other than, why can't I give loan to directors? Because, see, why I can't give loan? Loan to directors. No company shall, the company cannot. Section 185 prohibited giving loans to the directors. Directors of the company should not take the loan from company. That's why, because of this section, there also they said that you cannot issue shares to the, you cannot give loan to the directors. Other than directors, others. Directors or KMP. That's why in this section they use the word loans to directors, etc. Ejusdem generis. Directors, KMP, their relatives, all these people will come into the picture. Okay. However, section 67(3) makes an exception by allowing companies to give loans to their employees other than directors or KMP for an amount not exceeding their salary for a period of 6 months in the view of enabling them to purchase or subscribe for the fully paid up shares in the company or its holding company to be held by them in the way of beneficial ownership. Hey, listen carefully. Yeah. Normal provision is company cannot give any loan, guarantee, security or any financial assistance to any person to purchase its own shares or to subscribe its own shares. Point 1. However, there is an exception. A public company can give loan or any kind of financial assistance to its employees, provided that amount given as a loan should not exceed 6 months salary, and that purpose is to purchase its own shares or its holding company shares. Okay. Next, it is further provided, means proviso, that disclosures in respect of voting rights not exercised directly by the employees in respect of shares to which the scheme relates shall be made by the board report. Hence, Heavy Metals Limited can provide financial assistance up to specified limit, 6 months salary, to enable them to subscribe or purchase the shares of that particular company. However, directors and KMP are not eligible for such assistance. So, in this, employees who are not included, directors and KMP are not included. Okay. Sir, everyone please answer. Understood this section and answer clearly. Yeah. Next, what the questions came? Thank you, sir. We can get the details. Deemed dividend. Deemed dividend will be attracted not now. Deemed dividend covered by section number 2, class 22, subclass E, where the company is a closely held company or it is a private limited company under the Companies Act, and it declares any kind of, and it gives any kind of loan to any shareholder who is holding a substantial interest in the company, the amount which is bearing to the accumulated profit shall be deemed to be the dividend of the previous year and will be taxable under the head IFOS under special rates. That is deemed dividend. Section 2, class 22, subclass E. That is illa. Not to the directors, the substantial interest. Okay. Next, Debenture redemption reserve I am not going to cover now because debentures, deposits, charges one set. I will discuss separately. So I am not touching now. That's it, yeah. These are all some important questions that we need to discuss. The difficult ones in the share capital. We completed rights, we completed bonus, we completed buyback, we completed transfer transmission, we completed restriction on voting rights. Okay, we completed restriction on voting, we completed DVR issue. So all big concepts which are important for the exam, we have completed. Okay. Main questions are completed, yeah. Okay. If there is anything that is main, that is redemption of preference shares. See, redeemable preference shares, if you wanted to issue, first thing, article should authorize to issue redeemable preference shares. Okay. First, AOA should permit. Special resolution has to be passed. Okay. So at the time of issue of such preference shares, no subsisting default should be there in redemption of preference shares of any previous issue. Means already previous preference shares issue and you did not redeem them. Again, you are issuing new capital. Not possible. Okay. Next. This is all for your understanding sake only. Main point is tenure of the preference shares. The tenure of the preference shares generally will be up to 10 years. However, in case of infrastructure companies, housing financing companies, they can even go up to 30 years. But every year after 10 years, part redemption should happen. What redemption? Part redemption should happen. Anyway, debentures, the same concept will come. I will discuss there. Preference share is not that important for the exams also. Everybody, please confirm all the important questions in the share capital chapter from the exam point of view we prepared. Are you all comfortable with the share capital chapter now? All the big questions we have covered. Everybody. Okay. Yeah. Now, one question is not there here, but I wanted to cover it for purposes of understanding. See here once. Just a minute. Where I kept the document. Yeah. See here once. Variation in shareholders' rights, all these things are there, na? See, differential voting rights, follow the procedure properly. AOA shall authorize the issue. If AOA is silent, alter AOA. Permit by shareholders. Normal company, ordinary resolution. Listed company, postal ballot resolution. Voting power of DVR should not exceed 70% of total voting power. Voting power of DVR is can be multiples or fractions. No default in filing. No subsisting default in any of these. No special defaults to any of these. No penalties under these things, under any offense. Variation in shareholders' right. These are all small concepts here. If it is important, I will discuss in the class. Issue of shares at a discount, generally prohibited, but ESOPs ki, sweat equity shares ki allowed. Securities premium. When securities premium is issued, if it all issued over par, then securities premium will get created. Okay. If company follow Ind AS, securities premium can be used for three purposes. Issue of fully paid bonus shares, write off of discount and issue of discount and issue of equity shares, buyback of shares. Company do not follow na 5 purposes kit and use. Means above 3 plus write off of preliminary expenses and premium on redemption of redeemable preference shares. Rights issue. Employee stock options. What is an employee stock option? Employee stock option I wanted to discuss. It is an option given by company to directors, officers, employees of company, holding company, subsidiary company. So our company can issue ESOPs also to the directors, officers, employees of holding company, which gives director, officer, or employee right or benefit to purchase or subscribe the shares at a future date at a predetermined price. So future date law, at what price you will buy, I will decide today itself. Whatever the price on future date, I will give benefit to my employee. I will issue only at 500 rupee. If you want that benefit, stay in the company. So ease of intention is to retain the employees. Some important points I have written, those I am showing. Okay. So sweat equity shares, some people are asking. Sweat equity shares is a small concept here. See, wait a minute. Sweat equity shares is all about issue of equity shares for the persons who made value additions in the company. It's just a procedural compliance. I will cover sweat equity issue along with private placement. Along with what? Private placement I will cover, because you should know the difference between sweat equity and private placement. Prospectus chapter, when we do the revision, along with the private placement, we will read sweat equity issue, because so many points will be similar between both. Okay, it will be easier when you understand that. Next chapter. So we completed this. Next chapter, charges, dividends. So we are going to cover the next area called as what is the next chapter we are going to start? Declaration and payment of dividend. Declaration and payment of dividend. First of all, everyone, are you all present in the live? Yes, all PDFs, whatever I have shown, I will share with you. First, concentrate on this concept. Are you all with me? We are starting with a new area. Okay. So tomorrow's session, what we will do is, now we understood now it will take time. If you do efforts properly, it will take a little bit extra time. So what we will do is, tomorrow we will have a session not up to 10, we will keep up to 12. Okay. Same time we will start, but I will extend the session such that tomorrow we will put a big target. Okay. Today, if LLP is not completed, I will stop with dividends. Okay. This is a 5 marks chapter and that is a 8 marks chapter, 13 marks. Tomorrow's session, let us make a big one. I will cover FEMA, LLP, and interpretation of statutes. 10, 30 marks. Work done. Understood? 10 marks. 10, LLP 10, FEMA 10, interpretation 10. Let us target on 10 marks chapters. Let us take up to 1 o'clock, no problem. My point is not to put efforts. I will put all the efforts. I request same from you. Okay. Then 30 marks over. 30 plus 13 over. You are passed with these chapters if you do proper efforts. Okay. Next session, small chapters we will take. Deposits, charges, small areas we will consider and complete. Okay. Okay. But dividend chapter, there is no discount for you. You have to present half an hour to 40 minutes. Yeah. Enough to complete dividends area. Everyone, please answer. Shall we start with the dividends area? Management administration, third day. First I will cover management administration, then small chapters. Big chapters I will cover in revision. I won't leave any big chapter. Okay, you need not worry. Okay, let us begin. Declaration and payment of dividend. Okay. See, let us start with dividends chapter one by one. Please see the screen. Question 2. One is only just a definition. Practice question. This is another practice question. But this is a good question. Shareholders of Yuvraj Motors. So that's why my question bank will contain practice questions, previous practice manual questions, 2000 onwards, 40 exams, RTPs, MTPs, all I kept. That's why I am doing from this. If you are following any other question bank, do follow. I will not deny. But see the question here. Our motive is to learn. Okay. So the shareholders of Yuvraj Motors at a AGM unanimously passed the resolution for payment of dividend at a higher rate than that recommended by board. Board recommended 10%. Shareholders declared 12%. Can they do so? There is a no section is there. There is a regulation of table F. Regulation ET of table F in schedule 1. Although the power to declare dividend vests with the shareholders, under no circumstances they can declare a dividend exceeding the amount recommended by board. Means what? They can, if they want, they can reduce, but they can't increase. Board recommended 10. You can declare 8. Board recommended 10. You can declare 10. Board recommended 10. You can't declare 12. So not allowed. First answer over. Everybody answer. Did you understand or not? Yes or no? Okay, done. Next, May 2014, May 2018, 2 times question came, means something is there. CBA Limited wants to declare dividend in the year 2013 and 14, though it will not earn any profit in this year due to heavy losses. Company has been declaring dividend for the last 5 years. To maintain its reputation, the company wants to declare dividend this year too out of the accumulated past profits. Explain how the company can achieve this objective. Second question, same question, similar question. PET Limited incurred losses in the business up to the current year for the financial year 17-18. The company had declared at the rate of 12-15-18 respectively in the immediate preceding 3 years. In spite of loss, board of directors have decided to declare interim dividend at 15% for the current financial year. Examine whether as per the provisions interim dividend under the Companies Act. So this is what they wanted to tell you. Okay. See, first point number 1. Let us talk about this point first. Okay, which dividend? Interim dividend. Okay. See, first I will tell you one point that you have to write in exam. See here. Interim dividend, there are a lot of doubts in the minds of the students. Let us first clear those. Okay. Listen. Please, everyone, live students, stay effective. Have some concentration. Let us begin. Interim dividend. See, if you have any doubts now, you can ask after I discuss. Okay. After I discuss, you can ask the doubts, not now. Okay. Let me first explain what is interim dividend concept. Any doubts if there are, I will check first. No, they cannot increase as correct answer. Audit subject also provides some live like law. Yes, audit subject after this I will ask the my friend to take. He will be taking the live session for audit as well. Okay, all important standards he will be taking. So you can just listen to that. Let us first focus on this. See, interim dividend. Whenever I say concept of interim dividend, first understand one important thing in this. Whenever we declare interim dividend, sources you forget. First, we need to understand how interim dividend should be declared and what is interim dividend. See, understand the chart. This is 23-24 financial year, 31st March 2024. AGM 30th September 2024. Okay. 24-25 financial year, 31st March 2025. Next, AGM 30th September 2025. Okay. See now. D1, D1, D2. Okay. D1, D2. D3. D4. First copy down this somewhere. Live, if you complete discussion with me, you will understand, or else impossible to understand interim dividend. Complete when I am completing it. Okay, small change here. D4, D5. Copy down this first. Done? Okay. Now listen carefully. Now the discussion starts. See, the dividends chapter, if there is any difficult area, those are only 2-3 areas. First, interim dividend. Second, procedure to pay dividend in case of accumulated losses or no profits. Okay. Next one is understanding dividends kept in abeyance. That's it. Remaining all questions are very easy to solve. Easy going section. Just you need to remember the content. So we are in the most difficult one of all. So put some effort. You will understand it. See, what law said, let us understand. Generally, people think interim dividend means a dividend declared in the middle of the year. That answer is the most nonsense answer you can find in the entire planet. Okay, entire universe, not planet. Solar system ke the most funniest and nasty answer can be dividend declared during the year is called as an interim dividend. A new dividend will be issued during the year only then. For example, if I issue dividend on September, that is also issued during the year only, na? Anything will come during the year only. Then what is the point in that? So that's the worst answer that one can give. Okay, dividend declared during the year. Everything will be issued during the year only then. So that's not the answer. Any dividend declared between two AGMs, and you should declare between two AGMs, then the dividend is called as an interim dividend. Any dividend declared at the AGM, we call as a final dividend. We call as what dividend here? Final dividend. Now, everyone participate and answer. Okay, participate and answer. First, when I ask a question, comment should come immediately. This is FD or idea? FD ID. Final dividend, interim dividend. FD ID. Reply. Participation. Some are leaving. Participation. Very good. Very good. Super participation. So, answer is the final dividend. Perfect. Now listen. This is final dividend. Next, tell about D3, D2, D3, D5. D2, D3, D5. FDID. Perfect. All these three comes under interim dividend category. What is D4? What is D4? What is D4? Okay. So now, perfect. This is final dividend. Okay. Now, story did not end. Now it started. Listen. See. Okay, done. Stop giving the answers. Okay, listen now. Listen to the concept. Please see here now. Now the question is whether interim dividend or not is not the question. Interim dividend of which financial year is a question now. Tell me. 10th November 2024 means 10th November 2024 means it belongs to which financial year? This interim dividend belongs to which financial year? 24-25 or 23-24 or 25-26 or which financial year this interim dividend belongs to? Everyone answer, yeah? 23-24 or 24-25 or which financial year this dividend belongs to? The mixed answers we are getting. Some are telling 23-24, some are telling 24-25. What is this? That means people are lacking clarity. Sorry. They are saying some answer. I will not write. Tell next one. Done. Stop. Hey, Nilida. Stop. Next. D3. It was declared on 10th June 2025. It belongs to which financial year? 23-24 or 25 or 24-25, 25-26. Which financial this belongs to? D3. Again mixed answers. So November 10th, 2024, 2025, 24-25. June also 24-25. See the answers in the comments box, yeah? See what great people are answering. This is our clarity in the subject. Mixed answers are coming means mixed understanding is also there. See, that's why marathon here is not about reading and completing some exam questions in a bunch way. That's why I said very clearly it's a concept come workout session. Workout session logic illa. Just dabba, we will do questions and answers. But it's not the intent. At the end of the day, along with the questions, you should also learn the concept and do. Then in life, you will never forget. See the comments box, everyone. Come to the comments box once, everyone. See there. See once how mixed answers are coming. See, now we need to understand a concept here. Now stop. I will tell the answer. After that, you can understand it in a right way. Okay? See, whenever dividend is declared, listen, stop giving answers. Whenever dividend is declared after the financial year, before AGM, that dividend belongs to the previous year only. That's the rule. What does it mean? See, any dividend declared after financial year, before AGM, belongs to the previous financial year interim dividend. Observation. This dividend is declared on D2, declared on 10th November. After financial year, before AGM, after AGM. After AGM, this is interim dividend of 24-25 financial year. Next, D3. D3 is a interim dividend declared on 10th June 2025. This is an interim dividend which is declared after the financial year, but before the AGM. This is the interim dividend of 24-25 again. Again, it is 24-25 because it is declared even before the AGM of the previous year is concluded and the accounts are not yet adopted. This is an event occurring after the balance sheet date, which is a item that should be recognized in the books of accounts of the previous year itself. That's why 24-25 March 31st per week this will also come. Therefore, this is the interim dividend belongs to the financial year 24 and 25. Next, D5, 10th November 24-25. This is an interim dividend belongs to 25-26 because that's an interim dividend which is declared after the AGM. This is the answer. Write down. First, everyone reply understood or not? Copy down, copy down. Okay. So the final conclusion is any dividend declared, I repeat, any dividend declared after the financial year date, until 31st March, before AGM, that belongs, but that will be treated as an interim dividend of the previous year only. Because AGM is not yet concluded, that will be treated as an event occurring after balance sheet date. That's the question for question raised by Yuvasri. Can another person, Sidhu Vicky, is also asking a question. Sir, can explain why interim dividend declared 2 times in one financial year? Right? If the profits are excess and there is no investment place, what we said in FM, if the R is less than KE, means the company cannot invest at a place where R is greater than KE. For example, it cannot invest at a place where R is greater than KE. Company raises capital at 18%, but return on investment is only 16%, 15%. Then it is reduction in the wealth. Wealth is reduced. Our intention of FM is wealth maximization. At that time, rather than keeping with you and reducing their wealth, give it to them directly. Then I will give 2-3 times also in a year. Who are we to decide how many times interim dividend has to be declared? We don't know. Did you understand or not? The person who asked the doubt. Sidhu Vicky. Understood? Next. See here. So, what is the question is asking? PET Limited incurred loss in the business up to the current quarter of the financial year. See, there is a rule. Whenever you wanted to declare interim dividend, you can declare interim dividend out of surplus in profit and loss account. Which one? Surplus in profit and loss account. From that you can pay. Or profits up to the current financial year. Profits up to the current. See, the board of directors of the company may declare interim dividend during any financial year or at any time from the closure of financial year till the holding of AGM. Clear, man? Out of surplus in P&L account or out of the profits of the financial year. Out of the surplus in P&L account or out of the profits of the financial year in which such interim dividend is thought to be declared. For example, I am declaring on 10th June. Which financial year you have to see? Previous financial year. Anyway, profits will be calculated by 31st March. Na? From that you need to pay. So there are only two sources for paying interim dividend. Number one, surplus in profit and loss account. Number one, surplus in profit and loss account. Number two, current year profits. And a financial year for which you are declaring. Understood or not? These are the only two sources. That means the surplus means it's like a reserve extended. Now tell me, can we declare interim dividend out of reserves or not? Free reserves. Tell me, can interim dividend declared out of free reserves? Everyone. Can interim dividend be declared out of free reserves? Answer is no. Answer is no. Answer is no. Still people are putting yes. See, interim dividend can be paid only out of two sources. Okay. If you are declaring after the financial year, before AGM, okay, from the profits of that year you can pay. Point one. No, sir, I am declaring on 10th November, means after AGM. Then financial year not complete and the current financial year, then what to do? Surplus in profit and loss account only can be used. Sir, surplus in profit and loss account means what? That's called as a P&L account credit balance, not general reserve. Okay, that's called as a P&L account credit balance. P&L account credit balance is nothing but P&L account A. From the profits only, once it become a reserve, you can't declare dividends on interim basis. Interim dividends can be declared only out of surplus in P&L account or out of this profits of the current year. Okay, from the reserves you should never pay interim dividend. Okay, only surplus in P&L. Clearly said na here, out of surplus in P&L account or out of profits of the current year. Normal dividends they clearly said pay out of current year profits, past profit, like that they will tell. Here they clearly mentioned surplus in P&L account. P&L account credit balance can be used. Second one, current financial year profit. From those two only you should pay. For example, I wanted to declare dividend on 10th November 2025. Okay, how many quarters are completed? April, May, June over. June, July, April, May, June over. July, August, September over. October, November, December not yet completed. I am in the third quarter. Quarter 1, quarter 2, like, is there any loss? Yes, sir, loss is there. Then you cannot declare interim dividend on 10th November at whatever rate you want. You can declare only at rate of dividend declared in last 3 years average is the maximum rate at which you can pay interim dividend. Means any quarter up to, for example, quarter 1 loss, quarter 2 profit, or quarter 1 profit, quarter 2 loss, or both sides loss. In this case, this condition will apply. Means any time up to the quarter, the word is up to. There actually they used clearly. Up to missing. Up to the end, up to the end. Till then, if there is any loss, then quarter immediately preceding the date of declaration of such interim dividend shall not be declared at a rate higher than average dividend declared in the 3 financial years. So interim dividend can't be declared at whatever rate you want. In this case, they wanted to make a payment of 15. 12 plus 15, 27. 27 plus 18, 45. 45 by 3, 15. See here, 15. Is within the permissible limit. So board can do so. Everybody understood the point clearly or not? Interim dividend concept. Everyone reply properly. Understood? Third, Siddharth, you are asking about final dividend payment, not interim dividend. Interim dividend, these are the sources. See, I will give you one example. Hey, I'm talking to you. Listen. Ask doubt na? Listen properly. See, first thing, reading law is a greatest art. It's a gift of God. Okay, that one should inculcate within us. Being a legal advisors and chartered accountants, one of the greatest gift God can give us is best way of reading the law. Whenever you are reading the sections, always some sections have a limited applicability. By reading the section, you should understand that this section is of a limited applicability. See, sections are they use like this. Sections are they use like this. Dividend can be declared out of, okay, current year profit after providing for depreciation, past profits after providing for depreciation, or out of both. They are talking about final dividend. Okay, see, interim dividend section when we are discussing, If they do not tell about any source, then you can apply also this here, because the dividend includes interim dividend also. But interim dividend concept, they clearly restricted the scope. They said not those sources, first pay out of the current year profits, if there is any. You are declaring somewhere in the middle of the year, then you pay out of surplus in P&L account. Surplus in P&L account. So quarterly profits are calculated. Surplus is there. From that surplus you pay. These are the only two sources. From free reserves, don't dig and pay the interim dividend. Understood the point or not? This is the intention of the law. There 123 section, sir, they said dividend can be paid out of current profit, past accumulated profit. That's what they said, sir, in that section. That is a limited applicability. That is applicable for the limited purposes of 123, that too for a final dividend. Okay, I will give you an example here, which I will always give in class for you to understand. Okay, this example after Gnana bulb, ting, it will lit like this. Gnana bulb, ting. Listen, I will tell you a small kutty story again. Listen carefully. Not even story, you can understand this very clearly. Certain things in life, you should not take it very, very seriously. You should apply only for the limited purposes. School will be there na? During the school time. Okay. During the school time, we used to have pledge. Pledge. Everyone reply, have you ever done a pledge? India is my country. Have you done the pledge or not? Yes or no? Put the comment. Yes, na? At least once in life you might have done or not. But not fully. That is okay. But lady honesty here. Rishwan Pandian. Not fully. Fully okay. Fully or partially. Okay. So now answer my question. You have done the pledge. I have done the pledge. Everyone might have done the pledge. Okay. Pledge time, what we will tell, we will put our hand or we will put pledge and we will tell, India is my country. All Indians are my brothers and sisters. Okay. You will tell that or not? All Indians are my brothers and sisters. If you take it very seriously, then what you have to do? You should marry a Singapore or Malaysian girl. Understood the point or not? That is for a limited applicability, a school spirit. The intention of that pledge is not to really apply. For the limited purposes of school, behave properly. Do you understand the point or not? That provision kept in constitution for a limited applicability. You should not take extremely serious. School time, I said, all Indians are my brothers and sisters. Then how come possible? Therefore, I will go to Singapore, Malaysia, Thailand, America, USA, UK, everywhere. Like that, you should not behave. Na? Certain things you should not take extremely seriously. Provision has to be understood for the limited purposes. That's why whenever you read income tax, whenever you read Companies Act explanation for the purposes of this clause. Say for example, I will give you an example. Private company definition of what they will tell. Private company means a company which is having minimum paid up share capital, and by its articles it will restrict the transfer of share, limit the total number of members to 200 except in case of one person company, prohibit the public subscription of securities. Okay. For the purposes of this clause and for the purposes of section 2 clause 68, okay, for the purposes of section 2 clause 68, okay, the term private company, in that when you are reading that clause, multiple members, joint members are treated as a single member. Normally joint members are separate members. Say for the limited purposes of private company, means when you are reading private company concept, okay, in that context, joint members are treated as a single member, not always. Public limited company, when there is no limit on number of members, why joint members should be treated as a single member? I will treat joint members as separate members. Same. Understood the point or not? Understood the logic clearly. Same logic. Here also, all Indians are my brothers and sisters means, for the purposes of the school pledge, I told that. Don't apply in my real life. Gnana bulb, ting. Understood the point or not? So understand the act in a proper way. A general provision, that is in specific provision. So I think you understood now, right? Next. The board of directors of the company ABC Limited proposes to declare dividend at the rate of 20% on equity shareholders, despite the fact that they defaulted in repayment of public deposits. As per section number 123, subsection number 5 and 6, if you are defaulted in repayment of deposits accepted either before or after the company's commencement, such kind of company cannot go for issue of a dividend. They cannot declare a dividend. Okay. See, shall not declare dividend. Next. Same question here. Read the question. May 2015 question. Same kind of question or not? Everyone reply. Is this the same kind of whatever we already read or not? Okay. Yeah. So then next. See here. The directors of SOM Limited proposed a dividend of 12% on equity shares for the financial year 15-16. The same was approved by the general meeting on 20th of September. Directors declared approved dividends. Miss Nini was a holder of 1000 equity shares on 31st March, but she has transferred the shares to Mr. Raj, whose name has been registered on 20th May, who will be entitled to the above dividend. Oh, question is asked on section 126, read with section 123. Okay, read the question first. Good question. November 2016 question. Read the question first. Okay, so see the question first. Directors of SOM Limited or SOM Limited proposed to declare 12% on equity shares dividend. Okay, they proposed and board wanted to declare. Can they? Yes, they can. Okay, yes, they can declare. But the point is, as per 123 subsection 5, whenever dividend is declared, dividend must be paid to the registered shareholder, order of registered shareholder, or to the banker of registered shareholder, and should be paid only in cash. Okay, point number 1. Registered shareholder. Okay, see, there is a concept called as dividends kept in abeyance. Dividends kept in abeyance. Concentrate properly. See, I will tell 2 questions and I will combine 127 and 126. Both I will merge and explain. Okay, both I will merge and I will explain. See here, I will explain this way. On D0 until today, please listen carefully. X transferred to Y shares. Y paid consideration. Instrument of transfer executed. D60. Last date to send to the company for registration. Company has taken, say for example, company has taken 30 days to 25 days to register. This is case 1. Registration of transfer of shares. Second case, there is a dispute in a transfer. Previous chapter we already read, company has done that on 125th day, case 2. We already read the appeal, we will go, all these happened because of the delay happened in the procedure. Let us see the situation now. X transferred shares to Y. Consideration is received from Y to X. IOT is executed. Within 60 days, they sent to the company for registration. Up to their story is very much normal, plain going story. Now twist started. Company declared dividend on D70. Company declared dividend on D70. Now, company declared on D70. To the registered shareholder, they have to pay. To whom here? To the registered shareholder, they have to pay. Problem started. What problem started? Look at the scenario. D70 time, I sent the shares for registration, but not yet registered by the company. Okay. Middle, in the meanwhile, dividend is declared. Now, who is the real owner of this dividend? If you see on a plain slate, both are owners now for this dividend. Do you know why? X will tell that I am the main person to receive dividend because X name is still there in the register of members. It changed on 85th day. Y will tell that, Ennada anyayam? Nyayama pata, I have already given you money. So, then how come you will take, though your name is there, if you speak with legal intent, if you speak with some dharmam, then you have to follow, na? You should not be non-gratuitous towards a person, na? So I already paid you the money. So like said in Bhagavad Gita, Brahmagnecha Surapecha Chorecha Bhagnavrate Tadha Nishkrutir Vihita Siddhi Krutagnatah Nasti Nishkrutihi. So Sri Krishna said, Arjuna, Brahmagnecha, a person who kill a priest may be condoned by the god. Surapecha, alcohol, what to say, drunkard, may also be left by him. Chorecha, pocket mar, that person also may be left. Brahmagnecha, Surapecha, Chorecha, Bhagnavrate Tadha. Means what? Person who always promises something but never do that. That kind of person also, may God leave him. Krutagnatah Nasti Nishkrutihi. Means person who cheats another one. When the other person is helping you, such a person will never be saved, Arjuna. Please don't do that. That's why he said, Brahmagnecha, Surapecha, Chorecha, Bhagnavrate Tadha, Nishkrutir Vihita Siddhi, Krutagnatah Nasti Nishkruti. Same logic. Hey, I have given you consideration. I help you when you are in need. I paid you money, though the shares are not transferred in my name. Now you are coming and telling that dividend belongs to me. Like that people are saying. Do you understand the point or not? So, logic is very simple, yeah. They wanted to tell cheating, yeah, the literal cheating the people. So, therefore, lawmaker said, see, documents like X is the owner. Technically, Y is the owner. Now, who is the owner? God only should tell. No one is ready to save them. Therefore, lawmaker is a God here. They said, mouse, cat, fight. Monkey took the advantage. Same logic. Transferor, transferee. This belongs to me. Okay. No, this belongs to me. Both of you are fighting. A company will come in the middle. This does not belong to you. This does not belong to him. This I will keep with me. Now fight. Round 1, fight. Tekken 3, start. Mortal Kombat, start. Okay. Now you start fighting. Fight. Okay, now over a fight. Now see the law. Lawmaker said like this. I will not give to you. I will not give to him. Let the dispute get resolved first. Oh, how it will be resolved? Let the company register the shares. Understood the point or not? So what the lawmaker has said, what lawmaker said is, when dividend is declared at D70, don't declare dividend and give it to X because Y already paid consideration. Don't give to Y because X name is there in the document. Dividend will be kept at hold, withheld. That's called as abeyance. Dividends will be kept in abeyance. Keep with the company. Sir, abeyance means where they will keep, sir? Unpaid dividend account they will keep, sir. This dividend will go and sit in unpaid dividend account. Okay? 70th day declared. Whenever dividend declared 30 days, you have to pay. 25 days, 15 days, D85 ki, company register the transfer in name of Y. Now pay to Y. Dispute is settled. Now in the register of members, Y name is there. Payment is also made to Y. Fair deal. Now no fight. Pay to Y. If registration is cancelled in Y, then pay to X. Again no dispute. Directly can I pay to Y? Yes. When if X himself or herself said to the company that I have already taken consideration, dividends if any received after this date, 60th day, please pay to Y. If they say like that, then pay to Y. Or else dividends will be kept in abeyance in a dispute. Understood the point clearly or not? Everyone. Everybody answer. Understood? Okay. Next. Done. Next. Sir, this one, sir. This one. Here the problem comes. D125. D125. D70 dividend declared. D70 dividend declared. Dispute is there. X I can't pay because Y paid consideration. I can't pay because X name is still there in the register. Dispute is going on. Registration is done on 125th. Let us write down 120th day. Okay? 120th day. Ante, actually when you declare dividend on 70th day, D100 will be the last date to pay. But D120 ki problem is resolved. Now you will pay to Y. No doubt. But you are paying after 30 days. Na? If any dividend is declared or any dividend is declared and dividend is not paid within 30 days or warrants in respect thereof are not posted within 30 days, then company will be liable to a penalty at the rate of 18%. Directors are liable for an imprisonment of 2 years and directors has to pay a penalty of rupees not less than rupees 1,000 for every day of default. All these things will get attracted if there is any delay in the payment of dividend. But in this case, that penalty and interest will not come because this delay happened because there is a dispute. That is one of the exception provided by section 127. 127 section they say that whenever a dividend is declared but not paid, then penalty will get applied. Company has to pay interest at the rate of 18% for the defaulted period. Directors can not less than 1,000 penalty for every day, along with that imprisonment of 2 years, up to 2 years maximum. Okay, that will not get applied if the delay is because of dispute in the ownership. Okay, so this is what we need to understand. Same answer you have to write. If there is any stuff question, very, very important, then we will see. See, a Section 8 company is planning to declare dividend. First utter flop. Section 8 company means what? Any company which is incorporated for the purposes of promoting any charitable or charity or science, social education, social welfare or anything, and it is prohibiting payment of declaring dividend to its members and shall apply the profits only for the application of its objects. No declaration of dividend. Prohibited. Thus, cannot declare dividend. Okay. Super question. Let us read this. Okay. ESPN Heavy Engineering Limited is a listed company engaged in the business of providing engineering solutions to the clients across the country. Company followed consistent growth over the years. Rate of declaration of dividend is 15, 20, 25. Unfortunately, due to obsolescence of special part of machinery, company incurred losses in the current financial year. Nonsense here. Simple point is, company declared 15, 20, 30, 25 in the last over 1 point. Company declared losses in the current year. That's the main point. Even though during financial year 21-22, company declared interim dividend at rate of 10%. The board of directors of the company approved financial statements for the financial year 21-22 on 5th August. and recommend final dividend on 15% in this board meeting. General meeting of the company is convened on 31st of August. The shareholders of the company demanded that since interim dividend at the rate of 10% was declared by the company, so the final dividend should not be less than 20%. It was also submitted that rate of declaration of dividend immediately preceding 3 years is 15, 20, 25. But the company secretary emphasized the final dividend cannot be increased. Whether company can declare interim dividend if company incurred losses during the current year. Next, what do you think the decision of company secretary is correct? Justify your answer. Read the question first. Take time, read question, then we will discuss about the answer. Read the question. Stay live, everyone. Read the question first. Okay. Have you read the question, everyone? Give a reply. Have you read the question? Okay. See, simple question made it into a bigger part. Okay. Psychologically, when such question comes in exam, how student will feel, such a big question is there. Okay. Then everyone will get disheartened. So listen carefully. Nothing is there in this. There is a company declared dividend at these rates in the last 3 years. Company incurred losses in the current year. Even though during the financial year 21-22, company declared interim dividend of 10% on equity shares. Okay, 10% on equity shares. Next, board of directors of the company approved financial statements for the year 21-22 on 5th August, recommended final dividend at the rate of 15. General meeting of the shareholders was convened. Shareholders demanded, since interim dividend was 10% was declared by company, so final dividend should not be less than 20%. It was also submitted that rate of declaration of dividend in the immediately 3 years is whether company can declare interim dividend if company incurred losses during the current financial year. See, first, if losses are incurred in the current financial year, if the losses are incurred by the company, then the rate at which the dividend is declared, okay, should not be more than the average of the rates at which the dividend is declared in the last 3 years. 15, 20, 25, 15, 25, 40, 40 plus 20, 60, 60 divided by 3, 20%. Okay. See, first, 20% is the maximum rate at which you can declare. 10% declared. So that rate is within the limits. Okay, rate is within the limits. Provided you should pay out of surplus in P&L account. Okay, surplus in P&L account. Next, board of directors approved financial statements, recommend final dividend at 15%. These people are saying that they must declare at 20%. No, there are 4 rules. Okay, rule 1, rule 2, rule 3, rule 4. 4 rules are there to declare a final dividend. Rule 1, if the company is having accumulated losses, if the company is having inadequate profits or no profits during the year, then it has 4 rules. Rule 1, rate should not exceed rate of dividend in the 3 previous years average. Okay, first condition. Second, amount withdrawn from the reserves should not exceed 10% of paid up share capital and free reserves. Third condition, the amount withdrawn should be first used to set off current year losses. Balance only you can use. Next, amount in reserves, that means the balance after the withdrawal should not be less than 15% of the paid up share capital. 4 points I have written. 4 rules are the 4 golden rules that everyone has to remember if you wanted to declare dividend when the company is having inadequate profits or no profits. Number 1, rate of dividends at which you are declaring should not exceed rate at which the dividends are declared in the last 3 years. So rule number 2, amount withdrawn from the reserves should not exceed 10% of the paid up share capital and free reserves. Use the amount withdrawn first to set up the current year losses. Then any balance is still left out. A balance left out in the reserves after withdrawal should not fall below 15% of the paid up share capital. Okay. These are all the various conditions that we need to remember. Okay. So now listen carefully. In this question, no data is given relating to current year loss. No data is given relating to the free reserve. Nothing. Therefore, going only by point number 1, yes, they can declare up to 20%. But see the question here, what they said. Company demanded, you can't demand the dividend. Board of directors, if they declare 15, take 15 only. Just we can declare up to 20. That does not mean you must declare a 20% rate. Okay. So what he said, but the company secretary emphasized that final dividend cannot be increased. Final dividend can be increased. Up to 20% they can go. But shareholders can't demand. Board of directors voluntarily can increase up to 20 and they can declare subjected to the other 3 rules. This question is incomplete question. That's why I did not give answer here. Like these questions are not asked in exam. This is one of the previous exam questions which will never get repeated because there is a lot of inconsistency in the question. Do you understand the question or not, everyone? Answer. Everyone. Okay. Next. See. Unpaid dividend account. If we discuss about unpaid dividend account also now, so the main concepts of this particular chapter also will be complete because we read about 3-4 rules. We read about interim dividend. We read about dividends kept in abeyance. 127 section penalty also I said. Whenever dividend is declared, it should be paid within 30 days. If you don't pay within 30 days, company will be liable to pay a simple interest at the rate of 18% per annum for the defaulting period. Directors of the company will be liable to pay a penalty of 1,000 rupees minimum, maximum they will decide, and imprisonment up to 2 years. Okay, when liability will not come means number 1. Okay, one I already told you. First one, by operation of law. Second, shareholder have given an instruction to pay, but that instruction could not be complied by the company, and company has to communicate that it can't comply with that. Then no penalty, no punishment on company and directors either. Dispute in right to receive the dividend. Next one is, you have already made a lot of dues with the company. This dividend can be lawfully adjusted against the due. Fifth one, any other reason not due to the fault of company. In these cases, no penalty will be applicable, no punishment to the directors. 127 already completed. IEPF na just to read the credits and debits. Okay, 124 unpaid dividend account we are going to discuss now. With this, the main concepts of dividends chapter will be completed. See, Supreme Limited Declare dividend at the rate of, sir, another 15 minutes. Please stay live. 15 minutes, stay live. Exactly 15 minutes. Please stay live. Supreme Limited declared dividend at the rate of 10% on 10 lakh equity shares of 10 each on 30th September. Dividend warrants are dispatched to all the shareholders except 3 shareholders holding in total 50,000 shares due to dispute regarding the title. On ascertaining the position on 30th October, it was observed that dividend warrants of 1 lakh were not encashed by the remaining shareholder. Explain with reference to the provisions of unclaimed dividend. See, whenever dividend is declared by the company, has not been paid or claimed within 30 days to any shareholder entitled, within 7 days from the date of expiry of said period, transfer the total amount to a separate account called as unpaid dividend account opened with a separate bank in a scheduled bank. Separate bank account you have to open in a scheduled bank. Simply dividend declared. See, I will write the time limit this way. Remember. See here. Dividend declared. D0. Go. D5. Last date to transfer to separate bank account in a scheduled bank. This is not unpaid dividend transfer. Normal dividend you have to transfer. From here, D30. Here 5 days. Here 25 days. D30. Last date to pay the dividend declared. Even then you did not pay. Or some shareholders did not claim the dividend. You have given one bank account, the bank account is not working. I did not pay. But you can't keep it with you now. Okay, sir, I tried to pay, but that person bank account is not a proper. Therefore, that comes again to the company account. Correct or not, everyone? Array, you are there, you gave one bank account number. That dividend I have to pay to you. Okay, I tried to pay you, but your bank account is inoperative. Again came back to the company. That becomes the company money or not? Everyone, that becomes the company money or not? Everyone. Answer is no. Answer is no. That will not become your money. No, that will not become company's money. The moment a company declare a dividend, it is not money belonging to company. Okay. See, I will give one example for you to understand. A person is walking on road. Okay, when he is walking on road, he found one 500 rupee note on the road. He saw left, right, top, down, everywhere he watched. He sneaked everywhere, peeked everywhere. He did not see anyone seeing him. Immediately, he took that 500 rupee note, kept it in the pocket. One person saw him. He said, hey, I saw you. You have taken a 500 rupee note. This is a robbery. Okay. So now he said, no. I took the 500 rupee note. That is true. But I searched everywhere for the real owner. I could not find the real owner. Since I could not find, I kept in my pocket. Sorry. Now the other person asked. What the other person asked? Okay. You don't know who is the real owner. Correct? Correct. But you know that you are not the owner. You may not know who is the real owner. Understandable. But you know that you are not the real owner. So that's called as anyayam. Therefore, lawmaker don't encourage that. So like that you should not do that. I tried to pay, his account is inoperative. Therefore, that does not become your money. It's not your money. Whose money is a doubt here? Therefore, again dispute is going on. Put it in unpaid dividend account. That should be done D37. Okay. Within how many days? 7 days you have to do. Within 7 days you have to do. So this is the last date to transfer unclaimed dividends or unpaid dividends. Okay. You should transfer to an account called as unpaid dividend account, separate bank, scheduled bank. Okay. Separate bank account in a scheduled bank or account. Separate bank account in a scheduled bank. You have to transfer. Next. Within 90 days of such a transfer, within 90 days of such a transfer, within 90 days of such a transfer, prepare a statement of unpaid or unclaimed dividends. Okay, names, last known addresses, okay, amount pending, everything you should prepare a statement within next 90 days. Next, from the date of transfer, for a period of 7 years, it will stay in UPD account. Okay, 7 years completed. Transfer to IEPF account. Once transfer to IEPF account, okay, once transfer to IEPF account, you cannot reclaim any amount. During this 7 years time, real owner or the shareholder can claim unpaid dividend. This is the whole idea behind unpaid dividend account. But if you do not transfer within 7 days, there is a penalty for that. Refer section 124. Read it properly. MCQ they can ask a question. Okay. And moreover, shares also will be transferred in favor of IEPF. Means a person is not claiming shares, not claiming dividend. Shares also will go to IEPF. Shares in respect of that unpaid dividend also will go to IEPF. But if you claim dividend during the 7 years, then shares will not be transferred to IEPF. Everyone understood the concept clearly? Yeah. 124 section. Everyone understood clearly? Okay. Yeah. Next issue. So with this we complete 124 section as well. Remaining all are similar questions. Everything is similar. See, all interim dividend questions everywhere. That's it. With this we completed all the main discussions on the chapter dividends. Just do some exam questions on dividends chapter. Sir, hopefully everyone please answer. Understood the point clearly on the dividends chapter? Everyone? Yeah. Thank you very much. Tomorrow session again we will meet. Same time, same place. Tomorrow we are going to first start with first we will start with interpretation of statutes. Next 10 marks. Next we will come to LLP, 10 marks. Finally we will come to FEMA. Okay, we'll try to cover those three. So again, tomorrow also put efforts. We'll start at 6 o'clock, 6:10 between. We will begin and we'll complete till the syllabus, whatever our target syllabus is completed. Are you with me, everyone? Will you join live tomorrow, everyone in the class? Ah. So everyone, tell to your friends also, attend 30 marks we are going to cover. Kandipa, you should come to the class. Join live, complete it properly. Okay. How to get clarity in law like you are having? Nice question. Once law is completed, audit also will begin the revision. Okay. Fantastic way he will do. Yeah, you believe me, he will do the best revision for audit. Just it takes time for becoming popular. That's all. It will happen. Efforts will not go anywhere. Na? He will be there always. Yeah. So thank you very much, everyone. Bye bye. Prepare well. Tomorrow we will discuss again. We need to analyze law like you. If you want to analyze law like me, you put hard work like me. That's what in the recent reel I told. Na, people are looking into shortcut methods, looking at classes, taking the classes. Okay, that's not correct. Yeah, don't copy anyone. You will become a original. No one can copy you. They don't even try. If I remember 470 sections of companies, who will try to copy me? So you become you. You do your hard work, read the Bare Act, put time. And if you spend time, na, it's not at all difficult to become a person like me. You can easily become. It's not a thing which comes as a rocket science. By birth, it will not come. Na. We have to put efforts, that's all. That's what I said in podcast. It's very clear. Na. I will be very transparent and straightforward. If there is anything, I will tell on face. So point is, do hard work, put your hard work. Definitely you will also remember Companies Act. It takes time. Yeah, that's all. You have to put some effort in that. Okay. Thank you. Have lunch. Prepare well. Continue your day. All the very best.